6:56 p.m., but it's a minute behind, so it's actually 6:57 p.m., correct?
Correct.
All right. And what are we looking at here around this time? What of relevance comes up in this particular video?
So in this video, in approximately 8 minutes, the Nissan Titan door is going to open and the vehicle is going to drive away.
All right, and that's the truck you were referring to earlier.
That's correct.
Okay. All right, so we just observed that Nissan truck, and that is at 19:04:30, correct?
That's correct.
So that would be 7:04:30 p.m., which we now know is 7:05:30 p.m.
That's correct.
All right. Detective, real quick, because we just kind of looked through that. You've watched that video before, correct?
I have.
Do you see anyone get into that in the passenger side of that vehicle?
Not that I can see from the video.
Are you in the third one? All right, we're going now down to the third video. This is in- Can you connect it? Sorry, Judge, we're having some technical.
Okay. If you
We
Go
have,
to-
we have it on our laptop. We can
go
put it-
back to it and go open with and pick the program, sometimes it,
Look it up. This is currently on, it was on PLC video player. What are these on? Can you tell? Okay. Judge Ms. Schlimmer and I approach it. Corporal, so we're gonna connect the laptop. It's gonna show the exact same thing, and we'll figure out why the disk isn't playing.
Can you help me get it bigger? Where is it? Goes right here. Oh, look, it's working.
So now it's working?
He cleaned it off and now it's working.
Okay. Thank you. All right. So now, Corporal, we are now at 22:10:08. What time is that? And like for people who are not on military time?
It's going to be 10:10 p.m. on the video.
Okay. And which we know now is 10:11 p.m.
Correct.
Okay. Detective, real quick, what do we see in this video before? Well, hold on, just go ahead.
Judge, I'm just gonna object to the corporal narrating the video.
That's why I stopped. Now, Corporal, in this video, we see that truck that you described earlier coming in. Was that the significance of this video?
It was.
And again, in watching that video, do you ever see any children or anyone get out of the passenger side or anyone else get out of the vehicle other than the driver?
Yeah, I'm gonna object to the corporal narrating the video.
Right, overruled.
I do not.
All right, I'm now going to the fourth one. That's labeled 8/30/2022, 9:09 a.m. All right, Corporal, what is the time on this particular video at this time?
It's going to be 10:18 p.m. with 34 seconds on August 29th, 2022 on the video.
Okay. And what's the real time on that?
It's going to be 1 minute ahead of that approximately. So it's
10
10:19 and 34 seconds.
Okay. Okay, yeah, just leave it, let it play from there. Corporal, just for jury, where are we looking at here?
You're going to be looking just to the right of that Titan, to the left of it in the video, but to the right of it physically to the vehicle, which is where Shirley Bass's Mercedes is going to pull back in.
Yeah. And Corporal, while this is playing, where is their front door in relation to where this video is?
It's just off camera to the right.
Okay. So somewhat behind that Nissan truck on the video?
Correct. It's in the video would be in the area behind the truck, sort of obstructed by the leaves of the tree.
Yeah, just leave it, let it play through. Yeah, just go now. Now we're going to the fifth one down the line. Now, what's the time on this one?
This is going to be 10:26 and 59 seconds on the video, or 10:27 approximately and 59 seconds in actual time on August 29th, 2022.
So this is approximately 5 or 6 minutes after we just saw the last video.
Compared to the last video, it's approximately 4 minutes at this time.
4 minutes, okay, thank you. So Detective, we've moved forward a little bit on the video. We're now at what would be 10:30, 37 seconds, or 10:31 in real time.
Correct.
Okay, thanks. Yeah, there she is, right there. So this is 10:32, okay. Detective, it's now 10 3310, we see an individual walk past. Did you ever identify who that individual was?
I did.
And who was that?
It was Shirley Bass.
And Corporal, while this is playing, where the individual you identified as Shirley Bass walked to, the individual known as Daquan Evans who called 911, does he live back in that location where she was walking towards?
Yes, he does.
Okay. And Corporal, we're at 10:34:06, and it appears she has something in her hand. Is that correct?
That's correct.
And it's up to her ear. That's at the phone.
Correct. It looks like she has it at one point, at some points out at her ear, and then at some points in her hand, and she's looking down at it.
What's the other one?
Law enforcement arriving. I think there's another, hold on.
All right, we have one more. This is the last one. What time are we at here?
This is gonna be 10:35 and 26 seconds on August 29th, 22nd on the video. However, it's approximately 1 minute later also, so approximately 10:36 PM and 26 seconds.
Corporal, we see an individual walking around out there. Were you able to identify who that was?
The person at the far end or the person closer to the tree?
Closer to the tree right there.
I'm not aware if that person was identified personally.
And what do you say the person at the far end?
There's a person walking around near the area where Shirley Bass's C300 is, and I believe that's Shirley Bass.
Okay. All right, Corporal, we are now at 2241 or 1041, which I guess would be 1042. What do we see happening here in the corner up there?
This is capturing the arrival of law enforcement, the first law enforcement officers who arrived at the incident scene.
And do we see the law enforcement interaction with Ms. Bass at that time?
We do.
Okay. Yeah, I just remembered. All right, thanks. All right, Corporal, you had reviewed those videos back when you obtained it, correct?
Correct. When the sheriff's office obtained the video, I was able to review it.
Okay. Now, the person you identified as Shirley Bass, how long would you say, or how long were you able to time how long it was when the Mercedes arrived to when she's observed walking out of the house and walking around in the parking lot?
Judge, just again, I'm going to object to the corporal narrating the video. It's up to the jury.
All right, overruled.
It's approximately 8 minutes.
Okay. So what did you do next in your investigation?
So I forget what our last discussion point was as far as where we were.
You had obtained these videos and observed the videos.
So after observing the videos, in addition to what we've discussed about search warrants, I conducted additional interviews with Shirley Bass.
Okay.
I obtained a search warrant for a buccal swab for the defendant.
All right. Did you learn where Miss Bass had been earlier in the evening?
I did.
And
Objection hearsay.
Not to that question. Overruled.
And based on the information you learned about where she had been, did you follow up on that investigation?
I did.
And were you able to confirm that she was at the location that was identified?
I did.
And did you speak to people who were at that location who were there when Ms. Bass was there?
I did.
All right. So where were you able to, the location that she went to, were you able to determine what that location was?
I did.
And what was that?
It was the Ruth's Chris Steakhouse in the West Shore area.
All right. Now, did you ever obtain video that showed the Nissan truck after it left and pulled out on that in the first video we saw, or second video? I'm sorry.
Yes, we did.
Okay. Did you obtain? What did you use to obtain video to show where that truck had gone?
It's going to be called our HCSO Ion Crime System. The Ion Crime System is a series of cameras strategically placed throughout the county. Some cameras on the Ion Crime System are just cameras. They just record a feed that is captured for a certain period of time in accordance with the law. However, some of those cameras include tag readers, so they're license plate readers or LPRs. Not all intersections include a license plate reader. However, in the District 1 area, in the direction that a vehicle would typically travel to get from the Bass residence at the time to the West Shore area, there were at least 3 sites, 3 intersections that included cameras.
Okay. I'm publishing now what's marked as State's Exhibit number 8 that's been admitted into evidence. The first video I'm going to show, it states Fletcher, North 15th Street, F-160, enter. What are we going to see in this video?
This is going to be, if order is correct, as I recall, this is going to be a daytime video where the sun is out, and you're going to see the white Nissan Titan, which is clearly identifiable via it's lifted, it's got the black wheels, the features match Shirley Bass's vehicle, and it's going to be traveling westbound on Fletcher towards the Interstate 275.
So just to orient the jury, that was Fletcher Avenue that we're looking at?
That's correct.
Okay. And we see that truck going towards from the right of the screen to the left of the screen. Is that the westbound direction?
That is.
And that would be heading towards the interstate?
That's correct.
Okay. All right, I'm not sure if these are in the exact right order, so I'm going to play the next one that says 15th Street pole. All right, Corporal, so once again, we observed that truck you described crossing through. Is this from that same intersection?
It's the same intersection, however, this camera is pointed north on 15th Street.
Okay. And so, again, the directionality of that truck on this would be heading west towards the interstate.
That's correct.
All right, I'm gonna save that one. Let's go to all right, what are we looking at here?
I believe this is 22nd Street, which is to the east. So it is actually going to be slightly before, and it is also going to be the Nissan Titan traveling westbound.
All right, let me play it again. So just so for the jury, where is Fletcher Avenue on this?
Fletcher Avenue is the main road that's going from left to right, and then 22nd Street is the road that's going sort of, let me stand up. This is Fletcher Avenue going left to right, and this is 22nd Street.
In which direction is west for the jury?
West is this way towards the left.
Okay. I'm gonna replay that one since we didn't know that ahead of time, so. Sorry. All right. Go to the next one. All right, I'm going to pause this real quick. And what are we looking at here again?
This is just the same intersection, same time, just another camera also pointed northbound.
Okay.
Actually, I believe this camera may actually be pointed southbound.
All right, so I paused it at 22 seconds into this, or I'm sorry, 11 seconds into this video. we see a vehicle near the Exxon. Is that the vehicle in question that we're talking about, the Nissan truck?
It is, and I misspoke earlier, this camera is pointed northbound.
Okay. And so that Nissan truck would be heading in a westbound direction,
That's correct.
which would be towards the interstate.
That's correct. And this is before the prior video we saw from 15th Street, approximately 1 minute.
Okay. All right, now I'm going down to the one that says Fletcher, Nebraska. Oh, this didn't load properly. All right, it didn't load exactly properly, but what were we looking at in that video? And this is a video that says 9/2/2022 at 9:29 a.m. It says EOC Fletcher, Nebraska. I'll play it again, see if it loads right. No, for some reason it's not loading. Let me pause it right here though. Where are we looking at from this video, from what you can see from that part of it?
This is the intersection of Fletcher Avenue and Nebraska Avenue. This is going to be west of 15th Street and even further west from 22nd Street. This is approximately one traffic light or intersection before the highway for Interstate 275. This camera is pointed south. Fletcher Avenue is the main road where that silver vehicle is now traveling east on, and the vehicle in question is going to be traveling west on Fletcher Avenue.
Okay, so it would be going on this video left to right on it, correct?
That's correct.
All right, we just saw it. Was that what we saw past, the Nissan truck?
That's correct.
All right. Now, those were from earlier in the day. Did they correspond and match the times that you recovered those videos from the time that that you observed the Nissan truck leaving the residence at Heritage Club?
The times that we see the video, the vehicle on the Eye on Crime cameras traveling westbound were consistent with the vehicle leaving from the Heritage Club apartment complex and traveling west towards Interstate 275.
All right. Did you obtain video from later in the day showing that vehicle coming in the opposite direction?
Yes, we did.
All right. Go back up. Not sure why this computer is giving us a hard time. Try and play it again. Not sure why it's not loading properly, but. All right, at that point in time, we just see a white Nissan truck go by. Is that the truck that you are identifying as being the defendant's?
It is.
Okay, and do you recall what time it was that this was taken from the poll camera?
This is 22, I believe, 11 hours, so 10:11 p.m.
Okay, and in this video, that truck is heading eastbound, is that accurate?
That's correct.
And that would be back in the direction of where Heritage Club Apartments is?
That's correct.
And does that match up with the time that the truck is actually observed coming back into the apartment complex?
Yes, as part of my investigation, I conducted a query of the approximate timeline it would take to arrive from the intersections where we see the Nissan Titan during that date and that time and that approximate traffic pattern, and it was consistent with the arrival time that we see the Nissan arrive back to the apartment complex.
Finally, the last video, if it loads properly, we'll see. No. All right. All right, well, I think the jury understands, and so they'll have this back to look at. After obtaining the call detail records, do you obtain a, are you able to learn or follow where that phone goes there throughout that evening?
As part of the receipt of the call detail records pursuant to the search warrant that I authored and was sent over to T-Mobile, I received some location data, which was for the travel location approximate to the cell phone.
Okay, and where did, well, someone else will testify to that, but you, did it confirm that in fact, the vehicle, when the time the vehicle leaves, does it appear that the phone leaves as well?
We
That-
object to lack of predicate, lack of foundation.
Sustained.
Did you observe the map of the location data from where the phones were on that day?
I did.
Okay. And did you compare it with the video that you have of when that Nissan truck, Nissan Titan, leaves the residence?
I did.
Okay. And then with the location of travel, did the defendant's phone appear to match the location of travel of the Nissan Titan?
Same objection, Judge.
Sustained.
Did the phone in question, the defendant's phone that you obtained those CDR records from, did it appear to ping or be at the location or near the location of West Shore?
Same objection, lack of foundation.
Sustained.
Corporal, what did you do with the firearm that was obtained in this case?
That firearm was sent off to FDLE at the time of the initial investigation to FDLE for comparison to the shell casings recovered at the incident scene.
All right. And did you receive a report back on that?
I did.
All right. Did you submit any swabs to Florida Department of Law Enforcement?
We did, yes, we did.
All right. And as the lead detective, you know what evidence is being submitted, what evidence is not being submitted, and so forth, correct?
That's correct.
And you can make the decision of what evidence to submit as well, correct?
That's correct.
And did you submit the swabs from the firearm?
Yes,
Okay. And did you obtain any information back from those swabs?
yes, I did.
Okay. Based on that information, what did you do after that?
I completed, based on the conversation I had with the FDLE personnel responsible for overseeing that submission and the ultimate report, I completed a search warrant for Jermaine Bass, the defendant's DNA.
Okay. And did you submit that?
I did.
All right. And did you obtain a result back from that?
I did.
Based on the results you received from FDLE after the submission of the buccal swab of the defendant Jermaine Bass, what did you do after that?
I made a determination that I should also write a search warrant for Shirley Bass's DNA.
All right. And did you submit that as well?
After receiving the DNA, I did submit that as well.
Okay. Did you receive a return from Florida Department of Law Enforcement regarding that submission?
I did.
What did you do based on the return from that submission?
I sought to obtain the DNA from Jermaine Bass, and I also submitted the DNA for Jayla Bass.
Okay.
Jermaine Bass, when I say Jermaine Bass, I mean Jermaine Bass, the victim in this case, often referred to as JJ.
And for JJ, when you obtained the buccal swab, did you in fact go there yourself personally and meet with JJ and obtain the buccal swab?
I did.
And explain to the jury real quick, how does the buccal swab work? How do you do it if you're obtaining it?
Once a court order is signed and I'm authorized to, HCSO is authorized to obtain the buccal swab, I will don a fresh pair of gloves, get my my actual swab, which is a buccal swab. It's sort of like a long Q-tip, if you will. I meet with the person who's providing the sample. I will take the swab, 2 swabs come in 1 pack. I will then insert the swab into that person's mouth, swab both of the sides of the inside of their mouth myself, instead of having them do it. I will then package the swabs into their original packaging, impound them into evidence within an envelope.
Okay. Did you do anything else in this investigation?
There was an additional submission I submitted for the firearm recently, which went to our internal HCSO lab for the similar comparison that FDLA completed.
Anything else that you did, that you recall?
Additional interviews and additional submissions, evidence impounds, and things of that nature, mostly administrative work.
All right. Did you ever obtain the defendant's phone? Oh, you did, correct?
I did.
You testified to that earlier. Were you able to download the phone and to review its contents?
The phone was downloaded, however, there was no data of, usable data on the download.
Okay. Judge, if I may have a moment?
Yes.
All right, Judge, I'll pass the witness at this time.
Morning, Corporal.
Good morning.
How are you, sir?
Very good.
All right. As you indicated to Mr. Terry, you are in fact, or were in fact the lead detective in this case.
That's correct.
You were with homicide at the time. Since then, you were promoted, and now you're a corporal.
That's correct.
All right. So I want to talk to you first about contact that you had with Shirley Bass throughout this case. Okay?
Yes.
All right. Now, the first time that you had, and correct me if I'm wrong, the first time you had contact with her would have been at Tampa General Hospital on August 30th of 2022 when she was with her niece, China Gadsden.
That is incorrect.
What do I got
It was-
wrong?
It was at Tampa General Hospital, however, she was with her sister, Marlene Gadsden.
Okay, so and what date was that?
That was the same day,
Oh, okay.
August 30th, 2022 in the morning.
Okay. So the date is correct, it's just not China Gadsden, it's Marlene.
That's correct.
Gotcha. Now, at that time, you took an interview of Shirley and asked her questions about what happened, correct?
That's correct.
And would you agree with me, you asked pretty extensive questions, and it was not a short interview, correct?
Correct. The interview was approximately 1 hour long.
Now, is the next contact going to be on August 31st of 2022? You had made some phone contact with her to have her come back to the hospital because you had went to TGH and she wasn't there. Do you remember that?
Yes, the next day I responded to Tampa General Hospital in the morning, met with Marlene Gadsden, who advised Shirley Bass had stepped out. I met with hospital staff who confirmed she had stepped out. So I arranged to meet her I responded later in the day and met with her and conducted a second interview later in the day.
Okay. And in fact, hospital staff has Miss Bass leaving the hospital much earlier than what Marlene told you, correct?
The hospital staff had her leaving at approximately 9:30 in the morning.
Okay, and Marlene gave you a much later time.
Marlene, I believe she told me she stepped out for
Judge, may we
air.
approach?
Sure. Okay, so that's on August 31st, and then at some point Shirley Bass will return to the hospital.
Correct.
Okay. And you then, as you've indicated, conduct a second interview with her that day.
That's correct.
Was anybody else present with you in the room as for the first interview? Anybody present?
In the first interview, present total was me, myself, Detective Vertu, as the law enforcement investigators, and then Shirley Bass and Marlene Gadsden in the room, in that family room within Tampa General Hospital.
And then for the second interview, who's present?
Present with me during the second interview was Detective Brunel, who was another detective in the homicide section at the time of the sheriff's office, and Shirley Bass, and then a CPI was in the interview the entire time. However, during the interview, at some point for victim services, one of the victim specialists came in the room.
Okay. And that was pretty extensive as well, correct?
That's correct.
All right. Now, I have the third interview being the next day, September 1st of 2022. You have received the surveillance in this case, some of the surveillance we have looked at today, and you had some follow-up questions you wanted to ask Ms. Bass, correct?
That's correct.
All right. That's a shorter interview. That's brief.
Comparatively, yes.
Right, okay. During the course of this investigation, you found Shirley Bass difficult to reach on the phone if you tried to call her, correct?
At times, yes, she was very difficult to reach on the phone.
Okay. Now, the next contact I have for you, Corporal, is the execution of the search warrant that you got for Shirley's buccal swab. Is that correct?
That's correct.
Okay. And I have that date as May 7th of 2023.
Yes, I believe that's correct.
Okay. And at that time, you got the buccal swab from Miss Bass pursuant to the court order, and you asked her more questions, and you spoke with her about DNA and things like that.
I don't recall the substance. I executed the search warrant. I don't recall much more from the conversation.
Okay. It's in the, excuse me. In my folder. Okay. All right, so the search warrant that you got for Shirley's buccal is going to be similar to the same procedure you would use for a search warrant for Mr. Bass.
That's correct.
Okay. And you also indicated you submitted Jayla's known profile.
That's correct.
Right? And also, when it came to JJ, the son, his buccal swab was also submitted to the Florida Department of Law Enforcement.
That's correct.
All right. Now, did you get a court order search warrant? Was it voluntary for JJ? How did you go about doing his?
At the time of my response to, attempts to get a JJ's.
Judge, may we approach?
Yes?
No, you don't.
All right, so we were talking about how you got search warrants and all that for Mr. Bass, Mrs. Bass. The same type of procedure, correct, that you used for JJ?
Yes.
Okay. All right. all of these interviews, the first interview on the 30th, the second interview on the 31st, the shorter interview on 9/1, and the interview for the search warrant of Shirley to get her bugle, you audio taped all of those, correct?
That's correct.
Right. All right, I want to talk to you a little bit about JJ, Jermaine Bass, the son. First of all, could you tell the jury what is the Mary Lee House?
The Mary Lee House is a facility used by law enforcement. In the capacity that we use it, it's used by law enforcement to conduct what's called forensic interviews. That's where a group of trained specialists interview children, because children have, their interview procedures are much more delicate and different than an adult interview, or even a teenager interview. Small children are interviewed under a different set of circumstances with a different set of rules and by trained specialists in these types of investigations. So the Mary Lee House facilitates those interviews.
Okay. It's kid-friendly. It's to make the child feel safe.
Yes, I agree.
Okay. Now, is uniformed law enforcement ever present in the interview room when a child is being questioned?
We are not.
Okay. Now, you might be watching via closed caption on video.
That's correct.
Okay. All right. Well, I want to talk to you about the attempts that you made.
Judge, may we approach again?
Yes.
All right, back to what we were talking about. All right, so the first appointment was scheduled for September 7th of 2022 in the morning.
That's correct.
Okay. And who were you with?
I believe at the time I was with Detective Ratu.
For two, okay. Now, in that situation on that day, you arrived early, did you not?
I did.
Okay. And Miss Bass, at that point, shows up and refused to allow the interview to take place, correct?
Correct.
All right. And basically left Mary Lee House. Is that fair?
She ultimately did leave after a conversation with myself and the detective.
Okay. And in fact, since you were there early, you knew that she had arrived late, correct?
Yes.
All right. But in fact, she asserted she had been waiting an extended period of time.
Objection, Your Honor, hearsay.
Sustained.
Okay. All right. All right, so the interview did not take place in the morning of September 7th of 22 that day, correct?
Correct.
All right. And in fact, on that same day, is it true, Corporal, that you didn't even lay eyes on JJ?
That's correct.
Okay. Do you know if she had even brought him that morning?
I'm unable to confirm that personally.
Okay. Now, so when she refused to do the interview, did you take steps then to try to conduct a second interview, or actually a second attempt at an interview, later that day?
I did.
Okay. So we're on the same day, 9/7 of 22, and do you return to Mary Lee House now with Corporal Royal?
I did.
Okay. At that point, the interview did not take place either, did it?
It did not.
Okay. And it did not take place because JJ was uncooperative, correct?
That's correct.
Right. He was hitting his mother.
Correct.
He was poorly behaved.
That's correct.
He was disruptive and refused to speak.
That's correct.
In addition, JJ was being disrespectful to the adults.
That's correct.
So no interview is able to be conducted that afternoon.
That's correct.
All right. Now, at some point, a third attempt at an interview is going to be scheduled for September 12th of 2022.
That's correct.
Okay. Now, at this point, do you go on military leave?
I did.
All right. And who takes over for you on September 12th?
I believe Detective Brunel and/or Detective Ratu.
Okay. All right. And they both work with your agency, correct?
That's correct.
All right. And as lead detective, are you aware if the interview actually took place on that date?
It did not.
After that interview, the third attempt on September 12th, did the Sheriff's Department obtain an investigative subpoena and have it served on Shirley Bass?
Yes, we did.
Okay. Tell the jury what is an investigative subpoena.
An investigative subpoena is an order ultimately issued by the state attorney's office commanding a witness to be present for either an interview, typically for an interview, to provide testimony in relation to a case.
Is it voluntary, in other words? Can a person just say, I'm not going to appear?
No, it's not voluntary.
Okay. What could happen if a person doesn't respond to an investigative subpoena?
Potentially, they could face criminal sanctions.
Okay. All right. And as lead detective, you're aware that, in fact, was served on Miss Bass?
That's correct.
Okay. And it is served by, I believe, Detective Ratu and/or Detective Brunel?
Correct.
All right. Now, then, as lead detective, are you aware that the interview was finally completed on September 23rd of 22? And again, is Detective Ratu in your absence?
That's correct.
Okay. The interview was then able to be completed with JJ.
That's correct.
All right, so is it fair to say then, Corporal, that Shirley Bass was uncooperative with the attempts that were made by the Hillsborough County Sheriff's Office to have her son interviewed?
May I explain?
Well, was she cooperative or not?
There were times where Shirley Bass was uncooperative, and then there were other times where I personally spoke with her where she appeared fully cooperative.
Oh, okay. So half and half. She's cooperative at times, and she's uncooperative.
Correct.
Right. When it comes specifically to her trying to bring her son JJ into the Mary Lee house, however, you found her to specifically be uncooperative, did you not?
Not fully, because there was the occasion in the afternoon where she brought him in and was cooperative with us as we spoke with her.
Okay. You remember giving your deposition in this case?
I do.
All right, what's a deposition? Just tell the jury.
A deposition is where a witness in a matter pertaining to a court proceeding provides testimony to attorneys regarding the case.
Okay, and witnesses are under oath, right?
That's correct.
Okay. And did you in fact testify at that deposition that it is safe to say Shirley Bass was somewhat uncooperative when it came to attempts to interview her son?
Yes, that's
Okay,
accurate.
all right, thank you. And finally, before I leave discussing Mrs. Bass, I want to show you a transcript of the audio you did when you executed the search warrant on Shirley Bass, and it is just to refresh your memory if you discussed other things, okay? That's all I'm gonna ask. And you have this, I sent it to you. All right, may I put you witness, Judge?
Yes.
Okay, I'm handing you a copy of what has been transcribed as Shirley Bass search warrant execution. And this has been previously supplied to Mr. Terry. I don't want you to discuss the contents, just look through it. And I'm gonna ask you again if that refreshes your memory of when you took the buckle, did you discuss other things with her? Have you had a chance to look at a copy of the transcript of the execution of the search warrant audio that you conducted?
I did.
And does that refresh your memory as to whether you you asked Shirley questions and you spoke with her? You didn't just take the buckle, correct?
That's correct.
All right, thank you. I'll go ahead and take that back. Thank you so much. Now, you do have two contacts with Mr. Bass, correct?
Yes,
Do you remember? Okay. And basically, on those two occasions when you had contacts with him, he was cooperative with you and with your crime scene unit,
that's correct.
right? You had contact with him collecting his clothes, taking photographs on August 30th. Sound correct?
That's correct.
All right. And then you went back to get his buccal, like we've talked about everybody else's, on October 10th of 2022.
That's correct.
All right. Now, in this case, there's actually two separate 911 calls. DeQuan Evans calls, Shirley gets on the line. At some point, for whatever reason, the call is dropped, and then there's a call back, correct?
That's correct.
All right. And it is a true statement to say that you cannot fire 9mm ammo in a 380 automatic, semi-automatic.
As I understand from my experience with firearms, that is correct.
All right. Now, did you know anything as lead detective about the brown purse that was located in the children's closet?
No,
Okay. Were you aware, or are you aware as you sit here today, that there was 380 ammo in a box in a purse in the children's closet?
I was made aware shortly, or during this trial that occurred.
Okay. You found out during the trial.
Like, I found out during the trial.
2.5 years after this incident.
That's correct.
Okay. All right. Now, you had indicated that Mr. Bass's blue iPhone had been collected at the crime scene, correct?
That's correct.
All right. And you indicated you did looked at it and there was no significant or anything of evidentiary value for you to tell the jury about, correct?
That's correct.
And in fact, you did a Cellbrite download?
I
Or
don't,
tried to?
I don't conduct the downloads, but I believe at the time, Cellbrite was the application used to download the phone.
So that's what Cellbrite is. It's just kind of like you connect it to the phone and it'll shoot out all the data from the phone.
Yes. Cellbrite is a program that is, I believe, generates the report for reviewing the phones.
Okay. And that's pretty standard and routine that you will do that in cases where you'll have a phone, you get the search warrant, and you're able to attempt to do downloads of the phone.
Correct.
Photographs, you could get text messages, phone calls, social media, all of that.
That's correct.
And getting a search warrant for Mr. Bass's phone, that is also fairly routine as part of your job, correct?
That's correct.
All right. I wanted to ask you what you got in relation to that search warrant that you did for Mr. Bass's iPhone that was in the crime scene. You requested in your search warrant cell site lists. Do you remember that?
In the search warrant for the physical phone or the search warrant for the data?
The data.
Yes.
Okay. And in paragraph 7 of your search warrant, do you remember requesting timing advance records?
That's correct.
Okay. Do you know, as you sit here today, Corporal, what records you received in this case from T-Mobile pursuant to that search warrant?
I don't recall all of the records as I sit here right now. However, I do recall receiving call detail records and I believe data sessions, which are related internet connection, location information.
Do you know, and if you don't, it's fine, if you received anything above the call detailed record?
I don't recall.
Okay. And did you in fact ask Bethany Ross to do some work concerning Mr. Bass's call detail records?
I did.
Okay. I want to talk just a little bit about Mr. Bass's call detail records that we looked at here today. You had mentioned something about a phone call. It looks like it was 2234. Mr. Bass's phone makes an outgoing call to a number you believe to belong to his mother.
That's correct.
Okay. And was that call answered, do you know?
Based on the time, the duration of the call, it says completed successfully. However, based on the 5-second duration, Like I stated previously, that is consistent with me to be where the voicemail answered the call. The call was not answered by a person, that it went straight to voicemail.
Okay, in fact, the CDR lists 5 seconds.
That's correct.
All right. So, and as lead detective in this case, you're aware that the 911 call was at 22:33.
That's correct.
Right. So the 911 call is being made at 22:33, and a minute later, Mr. Bass attempts to call his mother, correct?
That's correct.
Right. Okay. All right. Now, I want to talk about Shirley Bass and the attempts you made in order to get her phone. Now, as lead detective, are you in fact aware that a...
Again, may we approach?
Yes.
Okay, so you're aware that a deputy, Deputy Creasy, had entered the crime scene and retrieved Miss Bass's phone for her.
Correct.
Okay. All right, and you were never able, as you sit here today, to do any sort of download from Shirley's phone.
That's correct.
Now, you did get a CDR, a call detailed record for Shirley Bass,
That's correct.
all right, and you do that via a subpoena.
That's correct.
Right, because you can get a call detailed record with a subpoena, but you need a search warrant to get into the physical phone.
That's
Is
correct.
that fair? Okay. Now, you, and who were you with when you spoke with Miss Bass at the hospital concerning taking her phone? Do you remember if you were with Detective Brunel or Detective Spencer?
I would have been, I believe, with Detective number 2
Oh,
on
sorry.
the first time and Detective Brunel on the second time of that day.
And when you say that second time, are these multiple attempts to try to ask her to give you the phone to download?
I believe it was all on the 31st.
Okay.
So the first time would have been when I spoke, you know, when I attempted to speak with her. However, she wasn't there. I was interested in getting the phone then. And ultimately, I did ask about the phone when I was present with Detective Brunel.
Okay. And in fact, you even offered with Detective Brunel, look, stay at the hospital. We'll take your phone. We'll-
Objection hearsay, Judge?
Sustained.
You offered to take her phone, download it, and return it to her at the...
Objection, Judge, hearsay.
Sustained.
You never got Shirley Bass's phone, correct?
That's correct.
You were never able to download it, correct?
That's correct.
Okay. All right, I want to ask you a little bit about China Gadsden. I understand that's Mrs. Bass's niece?
Yes, it is.
Okay. And you conducted an interview of her on October 23rd of 2023. Does that sound accurate?
That's correct.
All right. And prior to that date, in late 2023, there had never been anything relayed to you about a supposed meetup between Mr. Bass and his wife Shirley and China in their vehicle.
That's correct.
Okay. And in fact, there were times, and I don't know if it's once or twice, you can tell me, that you tried to call China Gadsden to speak with her, and she would hang up on you.
That's correct.
Right. You actually audioed that so we could hear it.
That's correct.
All right. The next topic I want to talk to you just a little bit about is some of the things that were done in this investigation. Did you ever request, or are you aware of any gunshot residue testing done on Mr. Bass's hands?
No.
Did you request, or are you aware of any gunshot residue testing done on Miss Bass?
No.
Either child, Jayla or JJ?
No.
Okay. And you do not attend the autopsy, correct?
That's correct.
All right. And are you privy, were you the one to have any conversations with the medical examiner's office concerning the issue of potentially getting GSR done on Jayla's hands?
No.
Okay. And in your situation, when you work for the sheriff's department, you're the lead, Ratu is your assist, Holbelman is the crime scene detective, and you're going to have other detectives that are going to help you out and do things in the investigation.
That's correct.
You've mentioned some names. We mentioned Brunel, Detective Spencer. Those ladies and other detectives helped in this investigation.
That's correct.
Okay. Shannon Bader had looked at the Mandalorian comforter and had used an infrared light and a swabbing to see if there was any gunshot residue on that. So I wanted to ask you, what follow-up did you do concerning what she took off the blanket or what she photographed?
There was no, I wasn't aware, the Mandalorian blanket, the primary follow-up was done after, later in the investigation related to blood.
Right, it's done later. Okay. So as lead detective, are you aware that she used infrared light and looked to see if there was gunshot residue and actually swabbed it? Are you aware of that?
Not specifically.
Okay. So it's safe to say, as lead detective, you are not aware, as you sit here today, of any results if Miss Bader had in fact swabbed that comforter for GSR.
That's correct.
All right. I want to talk to you just a little bit then about the video we looked at. You had mentioned, I want to make sure I have the times correctly. Did you say that the Mercedes leaves the apartment at 16:18? Was that right?
That was, so the 16-18 time is what I documented in my report.
Okay.
That is ultimately going to be because of a miscommunication in the initial message I received from Detective, I believe her name is, it was Detective Wheaton at the time, who was with Detective Spencer in the video collection. And the initial report I received was that the time was 16:18, but that ended up being incorrect. It was a typo. It was approximately 18:10 or 18:11.
Okay, about 18:10. And I'm not counting the 1 minute Mr. Terry has fixed with you because there was like a minute behind. Right?
Yes.
Okay. All right, so that's then 6:10 p.m.?
6:10 p.m.
Okay. And the Titan leaves 19:04?
Correct.
Okay, so that's going to be about 7:04.
Correct.
Okay. So then you do admit to this jury that you documented throughout your report that it was 16:18 that the Mercedes left and 19:04 that the Titan left, being a difference of 3 hours.
That's correct.
Okay. And do you also admit to this jury that you in fact did testify to that in your deposition as well?
Potentially, yes,
Okay,
yes.
all right. And in fact, one other spot, do you admit to this jury that in fact, that's what you put in the search warrant in this case?
Potentially, yes, because that's what would have been at the time, what I would have been relayed, that would have been relayed to me until I fully watched the video myself.
Okay, and I'm not asking what was relayed to you, but who did you speak to about that?
That would have been, I believe, again, Detective Spencer and Detective Wheaton, whose name is now Detective Miley, would have been working together at that time. I believe I actually spoke with now Detective Miley.
Okay, all right, thank you. That's Wheaton.
Correct.
Or was Wheaton, all right. Now, I didn't see any video from the Ion Crime from anywhere near the West Shore area. Did I miss something?
There was no video, there's no Ion Crime in the West Shore area.
Okay. Where is Ion Crime throughout the county?
I'm not sure of every location. It's strategically placed by the Hillsborough County Sheriff's Office.
Okay, but there's definitely some over up on Fletcher that we saw, correct?
That's correct.
All right. So all of the video that we looked at, that had to do with areas around Fletcher, correct?
Correct.
All right. How are you able to tell if you see a white truck pass by, like we saw, we're watching cars drive by, heading to or from the interstate? How do you even tell that that is Mr. Bass's Titan?
You can definitively say which vehicle it is when there is a plate read. However, there's not always a plate read because not every plate that passes by a camera is captured for various reasons, and not every intersection or camera has license plate readers.
Okay, so there's no license plate reader in this case, or is there?
I'm not, the license plate reader image, if it was, the scan, it's not captured in this case.
Okay, all right. So in fact, the video we looked at, you cannot definitively say, Corporal, that that is Mr. Bass's white truck, correct?
May I explain?
Go ahead.
Based on the visible features, I believe it to be Mr. Bass's truck. Absent that, I cannot say the license plate of the vehicle, but that license plate was attached to that vehicle as it passes by the cameras.
Gotcha. What type of visible features would be unique on a white truck?
Well, in this case, it's the make and model, which is the Nissan Titan. Its approximate year range based on its grille design. For example, the Nissan Titan was released for multiple model years, a very long time span. There was design changes in its exterior. It's raised and it had black wheels, the same features that were visible on Shirley Bass's vehicle.
Is that typical to all Nissan Titans?
Not every Nissan Titan would have those features.
Okay. Do you know the features of all Nissan Titans that are located within Hillsborough County?
I do not.
Okay. And when we looked at the video coming and going from the apartment complex, I didn't see people going in and out of cars. Did I miss something?
In both the vehicles, there is a figure that walks to the driver door of both vehicles that is visible in the video. However, their distinguishing features, who they are, is not visible in the video.
Okay. Got it. Okay. And may I have a moment? Corporal, thank you so much. We don't have any further questions.
Morning again, Corporal.
Morning.
So Corporal, you told the jury, when it comes to regards to Shirley Bass, she was cooperative at times, correct?
That's correct.
Okay, in fact, the day her child was murdered, she spoke with you for over an hour.
Objection, leading.
Sustained.
On the day she was murdered, did you attempt to interview her then?
I did.
And did she speak with you then?
She did.
How long did she speak with you?
Approximately 1 hour.
All right. And was it the day after, or how long after that you spoke with her the second time?
Approximately 1 day later.
Okay. And she spoke with you then?
Yes, she did.
And how long did she speak with you then?
Even longer, I believe it was approximately 2 hours.
Okay. Now, let's go to this attempt to interview JJ. Do you know the reasons why she did not want to have you interview JJ?
She specifically told
Well, don't,
me.
without telling you, did she tell you?
She did tell me.
Okay. Now, let's set the stage for this. This was on September the 7th, correct?
Yes, it was.
Okay. Her daughter had been killed on August the 30th, so approximately a week before.
That's correct.
Do you know whether she'd even had the funeral at this time?
Objection, relevance?
Overruled.
I know she was planning a funeral.
Okay. Her son had just gotten out of the hospital. Did the son just get out of the hospital?
Correct, I believe 1 day prior.
And he had been severely injured.
That's correct.
And this is his mom, who you are now asking to bring to this location with some strangers to talk.
Objection, leaving.
Sustained.
The phone in question, Miss Bass's phone, she did not give you the phone. Did she give you the phone?
She did not.
Okay. There are ways you can get a search warrant, right, for a phone?
That's correct.
But you need, what do you need to get a search warrant for a phone?
To get a search warrant for a phone requires probable cause.
Did you have any probable cause to get a search warrant for her phone?
I did not believe I did, based on the facts known to me at the time of the investigation.
And let's go back to the facts known to you at the time of the investigation. She asked, did you test for gunshot residue on the defendant's hand? You didn't do that?
Correct, I did not.
Did you know at the time that the defendant admitted he fired that gun?
I did.
Did you think that would add anything to the evidence?
I did not.
In fact, your understanding when you got there based on his statements was that he fired that gun.
Objection, leaving.
Sustained.
Based on your understanding of what the defendant said, based on what the defendant said, what was your understanding of what happened there that day?
Objection, improper opinion.
Sustained.
Did what he tell you affect how you do your investigation? Did what you hear what he said happen affect how you conduct an investigation?
It did.
Okay. Thank you, Judge. Nothing further.
All right. You can step down, sir. Thank you. He released from his subpoena?
He is not.
Okay. Is he to remain at the courthouse?
He is.
All right. Thank you. We'll take a quick comfort break, I believe the jurors have asked, so we'll be in recess.
All rise.
All right, have a seat. All right, ladies and gentlemen, I have one more, another stipulation to read you. Again, I'll just remind you, a stipulation is an agreement between both parties that it is a fact you are to consider having been proved beyond a reasonable doubt, in that the parties are not in dispute about this evidence. And in this case, the stipulation is as follows. Jermaine Bass, JJ, the son of the defendant, the victim named in counts 3 and 4 in the indictment in this cause, has been interviewed by both the defense and the state of Florida. Both sides agree that JJ has no memory of the events leading up to or occurring on the night of August 29th, 2022. Due to his lack of memory, the state and defense agree that he will not be called as a witness. And this stipulation or agreement is signed by Ms. Schlemmer, by Mr. Bass, and by Mr. Terry, the state attorney, and dated today's date. Any questions on that? All right. You can call your next witness.
State Trooper Bethany Ross.
Raise your right hand, please. Do you solemnly swear or affirm that the testimony that you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
You can step this way.
If you would please introduce yourself and spell your name for us.
Bethany Ross, Bethanyross.
Thank you.
Good afternoon, Ms. Ross. Oh, it's still morning. Good morning.
Good morning.
Please turn to the jury and tell them where you work.
The Hillsborough County Sheriff's Office.
How long have you worked for the Hillsborough County Sheriff's Office?
It'll be 10 years next month.
What do you do there?
I'm a criminal intelligence analyst in the Criminal Investigations Division.
How long have you been a criminal intelligence analyst?
About 6.5 years.
What did you do before that?
I was a deputy for about 3.5 years.
Now, when you become a criminal intelligence analyst, what's required of you when you transfer from being a deputy to a criminal intelligence analyst?
Yeah, you're learning completely new technology, completely new applications. It's all about getting information that the detectives may need for their case, and then obviously in a prosecution of a case later as well.
Give us some examples so the jury can understand what kind of things do you work on during your experience as a criminal intelligence analyst.
So I help identify people in a case, I help give them vehicle information, stuff like that, and then I also map a lot of different things such as cell records.
So when you're talking about mapping cell records, help us understand the process. What goes into mapping cell phone records?
We get provider information such as T-Mobile, AT&T, and Verizon. They give us like an Excel document that has latitude and longitude of, say, like the cell phone tower that cell phone connected to, and from there you can map that information.
Are you the one who generally requests these records from providers such as T-Mobile or Verizon?
No,
Who usually does that?
the detectives.
Now, once the detectives receive that information, what kind of information is usually inside of the packet that you get?
Yeah, there's got to be a date, a time, that phone number, the target phone number that they were looking for, who that phone number was talking to, if it was voice records, and then it would also be the tower information so that you can map that information.
I'm showing you what's been entered into evidence, and I'll put it on the Elmo here if I can have some help. Thank you. This is what's been entered into evidence as States 29. Is this an example of some of those records that you would receive in order to do your job as a criminal intelligence analyst?
Yes.
Okay, and did you in fact receive the documents from T-Mobile in this case that are included in this States 29 involving the defendant, in this case, Jermaine Bass?
I did.
When you receive these documents, help us understand what is the first thing you do when you receive call records from, in this case, for instance, T-Mobile?
I make sure that it has the relevant time that we are looking for, that it is the correct phone number, and then that there is mappable information within those records.
How do you know whether or not there is mappable information in the records when you receive it?
It's filled out in the latitude and longitude columns. It's filled out in the E-node columns, everything that denotes that a tower is being used and that tower information is present.
Explain to the jury how you became involved in this investigation involving the defendant in this case, Shirley Bass Jr.
The lead detective, Detective Gabo, asked me to map a certain time period of these records.
Now, tell us the phone number associated with the records that you were asked to map. And if you need your memory refreshed by your report or your map, let me know and I can do that.
Yes, I would have to look at the records for that.
Okay, I'm showing you what's been entered into evidence as State's Exhibit 21. Is this a map you created along with your experience and involvement in this investigation?
It is, yeah.
Can you read out to the jury the phone number that was used in order to map in this investigation?
That's 813-696-7195.
Do I have permission to publish to the jury, Your Honor?
Yes.
To aid in your testimony, well, before I do that, so you receive these T-Mobile records, you make sure that they have information that is mappable. What do you do after that?
From there, we use a program called CellHawk that actually takes that file and creates that map so that it's not like I'm hand drawing it. It can make that map.
You told us that you've been a criminal intelligence analyst for, what, 6 years?
Yes.
During that process of becoming a criminal intelligence analyst, did you receive training in how to use this program that you described as being called CellHawk?
Yes.
What's the training involved? Just briefly describe it for us.
Yeah, they take you through every step of getting the records, looking at the records, and then mapping those records and how to interpret that information.
When you put the records into the program, does it map it for you?
It does.
Then what do you do after it produces, this program produces the map?
I take a screenshot of that in order to put it in a document with all of that original information that we got from T-Mobile so that we can see it together.
So when you initially become a criminal intelligence analyst and you learn how to do CellHawk, do you maintain any sort of continuing education on the changes that happens with updating technology?
I do. I have to keep up to date with that stuff because it changes constantly. So at least once a year, there's webinars and a lot of different information out there that I'll keep up with.
And do you maintain that continuing education for the CellHawk process?
I do.
Tell the jury approximately how many times during your career as a criminal intelligence analyst that you've used this mapping process with this program called CellHawk.
Hundreds of times.
So in this case, the investigation involving Jermaine Bass Jr., the defendant, you receive his cell phone records from, who's the provider?
T-Mobile.
And tell the jury what you do next.
Once I have that screenshot, then I will put it together in a document to give to detectives and put in the case.
So I'm placing on the Elmo what's been entered into evidence as States 21. Is what we're looking at in States 21 an example of the mapping that you just discussed?
Yes.
So you use the information provided within the T-Mobile records, you put it in this program, and this is what it spits out.
The screenshot is, exactly.
Okay, so I want to talk about the map. Let's orient the jury what we're looking for in the map, okay? On the bottom left-hand portion, I see West Shore. I'm pointing to it with my finger. In fact, there is a line right through the word West Shore. Is that West Shore Boulevard here in Tampa?
Yeah, West Shore Boulevard is in that area, and that West Shore is denoting that that's kind of the area, West Shore.
Right above that, we see another line and another, it's two lines together. It looks like almost kind of a pie chart situation right above Tampa International Airport. Is that correct?
Exactly.
Can you zoom for the jurors, please?
Oh, sure. And for the record, I'm zooming in so that we get a closer look at what I just pointed out to be the West Shore in the bottom left-hand corner area and what the witness has described as Tampa International Airport right before that. Right to the left of Tampa International Airport, we see symbols that look like it would be some sort of highway with a circle, a white circle that has numbers on it. What is that representing?
Yeah, that's showing 589, excuse me, and this is using actually like Google Maps information.
And then if we go up in the middle, we're seeing two half pie graph almost situations. To the right about, we're seeing University Square. Tell us what area we're looking at now.
Yeah, the university area or the University Square area.
Right through that, we see yellow lines and a marker that is commonly known to be an interstate marker. Tell the jury what interstate marker that would be.
I-275.
Tell us about the text boxes that we see on the map. We're going to go one by one, but a general understanding of where does this information come from? Does the CellHawk program produce the map along with these text boxes?
No, the CellHawk program gave me that map, and from there I go back to those records to copy paste this tower information, the date and time, and that incoming or outgoing call information along with the duration into these little text boxes so that I can show exactly how that tower relates to the information that T-Mobile gave us.
Now, throughout the map, and again, we'll go one by one, we see what looks like lines that have like a half circle on them. I also see one that is a full circle. What do those symbolize? Just so the jury understands before we go one by one.
For that full circle, T-Mobile is not able to give us a direction, so we just have a 360 around the tower. For example, to the left of that, it's showing kind of southeast, and that means T-Mobile was able to give us a direction, which is southeast of that tower.
So what do these markers or the pie graphs or the circle, what does it indicate? You're saying it indicates a tower, but what about the tower?
That tower was in communication with that cell phone during that incoming or outgoing call.
So the purpose of the shape or the marker on the map shows us where the cell phone is at any given time?
It at least shows the direction from the tower that the cell phone was in.
Okay, so I want to start at the top text box. We see a full circle, which again indicates to you that the cell phone is bouncing off this tower,
Yes.
correct?
Yes,
But it's not indicating to you a location in which it's heading. Is that safe to say?
exactly.
Now, we see a line with, it's an arrow, to the right of the circle, and we see a text box that I'm pointing to. It's the topmost portion on the right side text box. Explain to us what that means, that text box.
It starts with the E node B, the sector, and the azimuth, which is all going to be tower information. That azimuth is blank. I just have a dash there because we don't have a direction, and that's actually where that would come from. The location is followed by that, and that's literally the latitude and longitude of the tower. And then we have the date and the time, and it was an incoming call from this phone number, 361-217-7632, and the duration is 0 seconds. There was no duration.
So we have that at 6:04:03 p.m. Next in time, we see to the left, two lines intersecting, right encompassing the words University Mall. It encompasses the two first letters U and N. Explain to the jury, and if you need to stand up and point or come over here and point, Judge, does she have permission to do that?
Sure,
If you
probably
can,
going to you is probably best.
yes, ma'am. If you can please come around so that you can point to yourself on the Elmo.
Make sure you describe with words too.
So specifically, and I'm going to rearrange. We see a top text box on the top left corner. I'm pointing to it right now. From that text box, we see a red or orange arrow pointing to the pie graph encompassing the first two letters of the word University Mall. Now, I noticed that this graph we're looking at, the symbol is different than the circle. And if you don't mind, can you come around this way and stand right there to point so that we're just not blocking the jurors? Can you point to the University Mall one and explain to the jury the difference between the circle we just saw and the information that it provides to you and this pie graph that we're looking at that's kind of like a semicircle with two lines? What's the difference?
So in the original one, the circle, right in the middle of that is going to be where that tower is, where that line is inside that circle. Instead, on this one, it's where these two lines meet. The tower is actually going to be right there. and we get that southeast direction because it's kind of facing southeast.
The semicircle that we see shaded in connecting those two lines, what does the semicircle symbolize to you?
This is just a display. It's half a mile out from the tower. That does not mean that the cell phone was half a mile out from the tower. It's a traditional kind of display for this type of information.
And let's talk about the text box that's associated. We pointed out before the top most left one. We see it says the E node B, the sector, and explain to us, the one before didn't have an azimuth. What is an azimuth?
Yeah, this azimuth is 120, and that's a degree out of 360 of a circle. So that 120 gives us the southeast. That's what the azimuth is.
So the 120 or the numbers next to the word azimuth indicate to you a directionality
Exactly.
of the cell phone itself or of the tower.
That's the direction the cell phone was in from the tower.
So the cell phone in relation to the tower, you can tell to a certain degree.
Yes.
Okay, so in this one, we see 120. Now, we see the location, which you indicated before is latitude and longitude, is that correct?
Exactly.
We see the date, 8/29/2022 at 7:15:21 p.m. Tell us what the outgoing call number is.
That's 813-516-3376.
Now, outgoing call, does that mean the number listed above, 813-696-7195, is the one who dialed out?
Exactly.
And if we see a label later on, incoming call, does that mean that the number listed below the words incoming call placed the call and dialed to 813-696-7195?
Exactly.
Okay, so the next in time, we see 7:16:04 p.m. For the record, I am pointing out a text box that is the second from the top on the top left side. We see an arrow coming from that, pointing to two lines that intersect with a semicircle. It is right below, encompassing the bottom portion of the N on North Tampa. I see that to be to the left of Busch Gardens, Tampa Bay. Is that correct?
Yes.
Now, tell us what information you were able to receive and what that line and semicircle means to you based on this information.
So exactly like before, those two lines intersect, and that's where that tower is. But what's different this time is it's facing northeast. In addition, we've got this incoming call from 813-516-3376, and it was a duration of 65 seconds.
So this number, 813-516-3376, placed a call that was answered by 813-696-7195, and we've previously identified that the 696-7195 belongs to the defendant. So let's talk about the next call in time. We see, let me get it on the map correctly. 8:37 p.m. We see it's the third text box on the left side, touching the left portion of the map. We see arrow coming below, and we see two lines with a semicircle right above the words Tampa International Airport. Tell us what information you were able to gather during your investigation about this specific time, August 29th, 2022 at 8:37:56 p.m.
There's actually another one that's at 8:20, which was just before it.
Oh, thank you. Okay, so 8:20, here we go. 8:20 and 43 seconds. We see, this one almost looks like a straight line with more of a semicircle than we've seen before, right below the words West Shore, with an arrow coming out the bottom corner of a text box. If you're looking at the graph, it would be second from the bottom text box to the left. We see at 8:29:22, at 8:20:43 p.m. Tell us what that symbol is, because it looks a little different than the other ones that we've seen so far.
I had to divide this one into the left sector and the right sector because that tower is used multiple times, but with different sectors. So this one in particular, 8:20, is the left sector, this one right here.
Okay.
And that's going to be an incoming call from the 3379 number, and the duration.
It's 3329.
Oh, I'm sorry about
Well,
that.
you are
3329.
backwards, so it's okay.
It's upside down.
Yes.
So, and that duration is 0 seconds on that one.
Okay, so what does the 0 seconds indicate to you?
It most likely was not answered, or it didn't complete.
Okay, so that's 8:20 and 43 seconds. Then we have 8:37 and 56 seconds. This is the one that we were talking about before, where there is a symbols above Tampa International Airport. Tell us what you know from your investigation of this specific symbol at 8:29 on August 29th of 2022 at 8:37:56 p.m.
So this one is facing practically north, and it's an incoming call from 727, let me not mess this up, 315-3329, and that duration is 0.
Let me just, I'm sorry. I'm gonna make sure this is in the correct position. So then we see a text box on the right, it's the right bottom quarter, and we see at 8:29:22 at 10 o'clock with 30 seconds p.m. Tell us what information that you were able to gather during your investigation about this specific area.
So we are now on the right side of this tower that we've talked about before, that's just in this West Shore area. And this is an outgoing call to 727-315-3329, and it was a duration of 15 seconds.
Right below that, included in the same text box, we see 8:29:22 at 10 p.m. and 54 seconds. Tell us what you were able to learn about that specific hit off the cell tower.
Yep, same, it's the same right sector here, and it's gonna be the outgoing call to 727-315-3329 for 5 seconds.
Let's move below the bottommost portion. We have, there we go, it's centered now. A text box on the bottom. And we see at 8:29 of 2022, 10:01 p.m. and 43 seconds, an outgoing call to 727-315-3329 with a duration of 43 seconds. Show the jury where that cell tower pinged.
So the tower is right here where these two lines intersect, and we're a little bit farther south from the other tower that we've been talking about, still in the West Shore area, and it's facing basically north or northeast.
Now we're going to, we're looking at the top quadrant. We've already discussed the topmost portion of the text box. And we see that the circle that we have has an arrow next to it with a text box we already talked about from 6:04 p.m. But below that, it looks like there's 2 other phone calls. So I want to discuss 8:29:2022 at 10:19 p.m. and 37 seconds. Tell us what you learned during your investigation.
So it is this one with the full circle here, and it is an incoming call from 727-315-3329.
Below that, oh, sorry, go ahead. Okay. Below that, we see it's within the same text box, August 29th of 2022. We see at 10:34 p.m. and 58 seconds. Tell the jury what you found out during your investigation.
That one is an outgoing call, and it is to 813-516-3379, and that duration is 5 seconds.
And that information indicates to you that this phone number belonging to the defendant called out at 10:34 p.m. and 58 seconds, correct?
Yes.
May I have just a moment, Judge? I don't have any further questions.
All right.
Do you want this?
Cross?
Good morning.
Good morning.
All right, so you are not here today testifying as an expert in cell phone mapping, correct?
I don't know if they've listed me as an expert, or I don't know.
All right. Have you ever been in court before and you are declared an expert? Are you aware of anything like that?
There was one time during a federal trial, yes.
Oh, okay. All right. All right. So basically, let me get the gist of what you do. You receive a CDR, correct?
Yes,
In this case, you received a CDR of Jermaine Bass, our client.
yes.
Right. You took that CDR, you plug it into CellHawk, which is the program.
Yes,
All right. And in your own words, CellHawk spits out the data, right?
it creates the map, yes.
Creates the map, right? And you said something about a screenshot. So CellHawk creates the map. Is it going to create exactly what we're looking at besides your additional boxes?
Exactly.
Okay. You take a screenshot of it, and then you're going to go what, back to the CDR, the same CDR you used, and make your little boxes?
Exactly.
Got it. Okay. What else do you do?
After that, I need to put it all together in this document, and this is a header that we typically use on all of these documents, so I add that header, and I'll
like
add my
the-
signature and the date.
Okay. Like prepared by
Exactly.
CIA Ross, and then up here HCO case. Okay. What do you do to validate what CellHawk has told you?
So what's good is with latitude and longitude, you're able to throw that into Google Earth, Google Map, whatever, and that is able to show the exact pinpoint that CellHawk has made where that tower is. That's how you can verify those records.
Okay. So is that your testimony that that's how you're verifying the CDR?
Yes,
Okay. But that again is going to come, the latitude and longitude, from that CDR.
from T-Mobile, yes.
Okay. Now, in terms of where a tower is located, did you do any verification of what CellHawk spit out by doing a drive test?
No, that's not typical for us.
Were you ever requested to do a drive test?
No,
All right. This CDR that you were given it by Detective Gabot, correct?
yes,
All right, he gave you a specific date and a specific time.
yes.
All right. You did not receive CDRs from any other individuals, correct?
No, not that I recall.
Okay. I wanted to ask you a little bit about, for example, when we see a zero duration in the map you made, you agree with me that T-Mobile doesn't really give you in very plain, simple English if a specific call with a zero, if it was answered or not, correct?
Exactly. You have to, yeah, you don't know.
You don't know, okay. And in fact, isn't it true that there could actually be other calls as well that are not mapped? CellHawk doesn't map them because, for example, there are some reasons it just didn't connect, that call didn't connect to the tower, it was iPhone to iPhone, or there could be signal issues. So there might be other calls, and for some of those reasons, they won't get spit out by CellHawk.
Yes, they can't be mapped because that mapping information just doesn't exist.
Right, okay. Now, did you use a cell site list to verify your data?
Yes.
Okay. Which cell site list did you use?
So T-Mobile has uploaded to the CAST team on LEAP. It's a government website that the FBI uses. They have cell phone towers uploaded into there on a regular basis, and that's the one that we use within CellHawk.
Okay. Did you use it specifically in this case?
I did.
Okay. Which version, or what was the date or approximate date of the cell site list from T-Mobile did you use?
October of 2022?
All right. Were you aware that in August of 2022, T-Mobile and Sprint merged?
I don't know the exact date, but I know that they merged.
Okay.
Yes.
And you used October. Is there another one also in December of 2022?
There should be, yes.
Okay. Now, when you're on CellHawk, you get a little box that even pops up and tells you, you better use that cell site list because that's the best practice, right?
Exactly.
All right. And it's your testimony you did that in this case.
Yes.
I wanted to ask you and just clarify a little bit about this azimuth. So let's look at the one from 715. For example, we have it as upper left-hand corner of your map, 71521, pointing over to that very first, what do you call that? With the lines and the shaded circle.
Right here.
What do you call that?
This is like a sector.
Sector, okay. And so that's that first sector, correct?
Yes.
All right. So now, what is the azimuth for that sector?
That one's 120.
What does that mean?
It's 120 degrees of that 360 degree of a full circle. So they choose 120 to be that southeast portion.
Southeast portion, all right. So you're not telling us that that phone is in that shaded portion, correct?
Exactly, that
Right.
is not the case.
Right. What's the radius? Can you tell us what the radius would be of where that phone may be?
No, these towers, this information does not have like a radius and a distance from the tower, just the direction.
Right. So in fact, all you can tell us is what you have plotted, that that cell phone is in that direction from that tower.
Exactly.
Okay. It doesn't mean it's in that shaded area at the time.
Right, exactly.
It just means it's in the direction from the tower. So in this case, we would have, I think you said, is it southeast, or for that first one, it's 715?
Southeast.
Southeast, okay. So we don't know how far, it's not in the shaded area, but somewhere that phone is in that direction, southeast, from that area.
Exactly.
Okay, simple as that, right?
Yes.
All right. So you're not telling this jury you can place an exact location of a phone?
I cannot.
Okay, you cannot give us a location if it's at a restaurant or sitting on the interstate, you can't give us any of that, correct?
Right.
Okay. And you cannot, with the records you received in this case, give us any idea how close to the tower itself that phone may be.
Right.
Did you ever receive timing advance records in this case?
I don't recall if I did or not.
Are those a little bit more accurate in?
So they may have that distance from the tower that we talked about before.
Gotcha. Are you aware that when Detective Gabot did his search warrant in this case, and he just talked about it, that he requested timing advance records?
I don't know.
You use timing advance records pretty commonly in this,
Yes, when we do get them.
and you're gonna get better information.
Sometimes, yeah.
Okay. So in this specific case, the only thing you had was the CDR data, not any sort of more accurate timing advance records.
As far as I remember, yeah.
Okay. All right. Besides the CDR itself, and we have it in evidence here, what else do you recall actually receiving from T-Mobile, if anything?
It comes with possibly data information. It depends on how they package it and give it to us, but I use just the voice records on this one.
All right, we're not talking about data, use of data?
No.
Okay. All right. Looking at my notes to see if I have any other questions for you. May I have a moment?
Yes.
Thank you, Judge. My co-counsel has reminded me, please just tell the jury what a drive test is.
A drive test is, you use a device, this sort of like box that goes with you in the car when you physically drive by a cell phone tower, and that's how you can also confirm these azimuths and these latitudes and longitudes and stuff of the tower.
And you cannot testify to the accuracy of these actual CDR records you received. You're just relying on that data.
I rely on the data that T-Mobile provided, yeah.
Thank you so much, Ms. Ross. I don't have any other questions.
No redirect, Judge.
All right, you can step down, thank you.
Thank you, Your Honor.
Is she released from her subpoena?
Yes, Judge.
She is not, but she can leave the
She is not, but she can leave the courthouse?
Yes.
All right, thank you.
Thank you, Your Honor.
All right, we will go ahead and take our lunch break at this time. It's 5 till 12. I will see you back here at 1:15. Same admonitions you always get, and enjoy your lunch.
All rise.
can keep making changes.
Yes.
Okay, so on page 2, the lessers. The lessers of first-degree murder or second-degree murder, manslaughter.
Well, yes, on the first page, the middle, this is the only page where I saw it, the middle name is ANDA. In the heading and in the first sentence.
LAVANDA?
Yes, and you have it correct in the rest of it, it was just that one page.
LAVANDA. I cut and pasted it, so it should be wrong the whole time.
It's not.
I guess not, okay. I'll check for that and then throughout, just to make sure. Thank
It's on
you.
the bottom too.
Okay, yeah, I'll do a search and replace.
Okay.
All right,
Judge, the only thing I have on that is when it comes to felony murder, there's a third-degree felony murder.
on page 2?
Yeah,
Okay, yeah, that's where I'm getting there. So the lesser crimes included in the definition of first-degree murder are second-degree murder and manslaughter?
in third-degree felony murder.
For the first-degree murder, there's a third-degree murder?
Yes.
All right.
Third-degree felony murder.
All right. Lesser crime for ag child abuse is ag battery and third-degree felony murder?
No, it's just aggravated battery.
Third-degree battery.
Okay. That's what you were trying to explain to me that I didn't comprehend.
Yeah.
Got it now. Thank you. Lesser crimes in attempted first or attempted second, attempted manslaughter. There's no attempted third though, right?
No.
No.
Right, okay. So, page 2, intro to homicide is all standard.
You just have to add the third degree felony murder to that as well.
Oh, yeah,
On the second paragraph and the third.
okay. Page 3, 7.2, first degree premeditated murder. Are you asking for heat of passion? I don't,
Yes, Your Honor.
I don't know what evidence there has, but I'm in heat of passion, Judge.
I just think based on the timing of the events and the fact that it's gonna be a circumstantial case as to what happened in there, I think that, that should be given.
well, his own statement says it's an accident. That's the only evidence I have right now.
I agree, Judge. That's the state's position as well.
Well, the state in their opening talked about some kind of, issues going on in the Bass household, as well as what China Gadsden said in the drive home. They made a point of how quickly this happened from the time that Shirley's car arrived and my client's car arrived. So I think based on the timing of the events, that they're gonna say it happened quickly from the time that she got home, which could be inferred by that evidence that this is something that just happened.
Right, is Miss Bass gonna testify?
No, Your Honor.
Is Mr. Bass gonna testify?
I don't believe so, Your Honor.
All right. Well, I'm putting a big question mark by that because I don't know that I have any evidence. I mean, there has to be something in the record. Sudden event, suspended the exercise of judgment, lost normal self-control, no time to cool off. I mean, there's just no evidence that anything like that happened.
I agree, Judge. The state is not requesting this instruction. It's in fact asking that it not be given.
Well, you had China Gadsden testifying, if you believe her version of events, that the truck is driving erratically, pulls over on an entrance, has some kind of confrontation, and then shortly after that is when all these events go down. And I would assume that the state in their closing are going to talk about the short time frame from the time that Shirley gets home and the kids are shot.
Judge, all that shows is aggression on his part. It doesn't show any sort of sudden event that's suspending any judgment. It doesn't show anything that would make someone lose self-control. There's nothing in there that would show heat of passion.
That's up to
Because
the
he's
jury to
angry and being
decide.
aggressive does not qualify as heat of passion. If that's the case, then in every single murder, someone kills someone, usually it's they're done in anger. But this is for when there's been some sudden provocation that would cause someone to lose control. There's no sudden provocation, or at least there's been no evidence of that. It has to be something done to them, not something they do themselves.
All right, I'll come back to that. Felony murder in the first degree, 7.7. As to the two elements, you had and or there, but I think it's just or. Because you don't have to prove both things, you only have to prove one, right? Am I misreading that?
Well, unless, I mean, it could just be or, but it also could be and, like for both of them. But yeah, if you want to just do or, that's fine. I just don't want them to think that they have to choose one or the other. But I see what you're saying. And that's fine, Judge. If you want to take out the and, I'm okay with the state. There's no objection.
Yeah, I think to be safe, it just needs an or.
Okay.
Because there's a lot of criticism about when we use and or in jury instructions.
Okay.
Y'all agree?
That's fine, no objection.
What the standard says is give to A and or to B as applicable, but
Right.
it doesn't necessarily say that it's and or in the middle of it.
Right.
So that's fine.
Okay. Then page 5, murder in the second degree. Again, you're asking for a heat of passion.
Yes, Your Honor.
Again, the state's objecting.
All right. And then should come third degree murder. Right?
Third degree felony murder, yes, Judge.
Yes.
And I sent you an instruction, I believe.
All right. I'll cut and paste there. Then manslaughter on page 6 and 7, are you asking for culpable negligence?
I would ask that it be included, yes, because I think an argument could be made that if the jury for some reason believes that maybe it was the boy who did it, that by leaving the gun in a location where the boy would have access to, this could be considered culpable negligence.
All right. And for count 2 and 4, count 2 and 3, ag child abuse. I'm just gonna say Shirley Bass in count 2 and Jermaine Bass in count 3. And aggravated battery as a lesser on page 8. Yeah, I'm gonna say in count 2 and in count 3. Then intro to attempted homicide for count 4. All that's standard. Page 9, attempted first-degree premeditated murder. Attempted second. Attempted manslaughter.
You on page 11, Judge?
Pardon?
You on page 11?
Yeah, I'm looking back to see if the heat of passion would apply to attempted first, then it would.
I don't think you can have heat of passion for an attempted.
I don't think so. I was just thinking that either.
Yeah, it doesn't have it in the standard.
Right. Okay. Yeah, so on page 11, attempted manslaughter. Then the 775-1 enhancement, 3.3A, first, second, manslaughter. Attempted first, attempted second, attempted manslaughter. And no enhancement on counts 2 and 3. Correct? Yep, it's not alleged in the charging document. Count 3 only, and 4 and 2 only have 775-0872. So that's the actual possession. So, what about third degree felony murder? That gets any murder. So that gets attempted first degree murder, second degree murder, third degree murder, or attempted third degree murder gets a 775.01 enhancement. And then does it also gets a actual possession enhancement, right? Because it's any degree of murder. It says murder upon a human being, so that would include third.
Correct.
Attempted second, attempted third. And ag child abuse, but not ag battery, we determined that. Correct,
Correct.
everyone?
Yes, Judge.
All right, so I'm taking out ag battery. All right. Defendant statements, 3.9B. Voluntariness of them on page 15.
Yes, Your Honor.
Yes, okay. In weighing the evidence on 13, I assume you want inconsistent statements?
Yes, Your Honor.
Money, preferred treatment, or other benefit,
Yes.
pressure or threat,
Yes.
conviction of a felony or misdemeanor,
No.
general reputation,
No.
expert, yes, accomplice, no, child, no. 14, no.
I don't believe so, Your Honor.
All right. Not testifying, yes. And then legally interlocking counts, did you send me something else now?
I sent something over lunch, Judge.
Okay, I haven't read that yet, so I'll keep working on that. Did you happen to look at what he sent over lunch?
Yes.
Any thoughts?
No, it looks similar to what he sent last night. He only just added an additional paragraph for third-degree felony murder.
Right. And how about the verdict forms?
James?
Judge, when I did these, I did not add felony murder in the third degree.
Murder and the felony murder. Okay, so that would be felony murder, third degree. Manslaughter.
Count 4, it should say attempted murder in the first degree murder.
Yep. Attempted. And on count 4, they don't have to choose between felony and premeditated, do they? Like we did in count 1?
I don't know, I've never done that before in that count.
I haven't either, that's why I was wondering.
Do I have attempted felony murder in
Do you have?
there? Did I include attempted felony?
Because that
Yeah.
should be for, which one are you talking
Oh,
Felony wouldn't be necessary.
I don't think you do have attempted felony murder.
about? Yeah, it shouldn't be,
Yeah, I don't think I added attempted felony murder.
right, it's just attempted first degree premeditated,
So that's the only thing, right?
Yes.
yes,
So then, no, those questions aren't necessary.
Those questions are nice.
All right.
correct.
Because it's viewed as a felony applicable to count 1.
Yes. I
Yeah.
believe so.
All right, let me make these changes then. And we're ready. Your witness ready?
Yes, Judge.
Still no Shirley Bass?
Yes, Judge.
Okay, thank you.
All rise.
Jennifer Michael.
All right, have a seat. How was your lunch break? Great. All right, the weather's nice out there, huh? I wouldn't know, I didn't make it out, but I'll take your word. All right, the state can call your next witness.
The state calls Jennifer Michael.
Raise your right hand, please. Do you solemnly swear or affirm that the testimony that you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, ma'am.
You come this way.
Good afternoon.
Good afternoon.
If you would, please introduce yourself and spell your name for us.
My name is Jennifer Michelon, Jennifer, Michelon, Michelon.
Good afternoon.
Good afternoon.
Tell the jury, where do you work?
I work for the Hillsborough County Sheriff's Office in the Firearms section of the Forensic Service Bureau.
How long have you worked with HCSO in the firearms section?
I've worked there for 2 years.
What's your title?
I'm a Forensic Laboratory Firearms Analyst.
I'm writing that down so I don't get it wrong. Forensic Laboratory Firearms Analyst. What does a forensic laboratory firearms analyst do?
My main duties are to determine whether or not ammunition components, such as a fired bullet or a fired cartridge case, were fired in the same firearm or from a specific firearm, firearm function and safety testing, serial number restoration, and database entry.
Before you started at HCSO, did you work elsewhere also with firearms?
Yes, I did.
Where did you work?
I worked for the Florida Department of Law Enforcement in the Firearms section of the Tampa Crime Lab.
What was your title when you worked for the Florida Department of Law Enforcement, we also call it FDLE, in the Firearms Department?
My title when I left was Senior Crime Laboratory Analyst.
What did you do at Florida Department of Law Enforcement as a Senior Crime Laboratory Analyst?
I did the same thing that I'm doing at Hillsborough County Sheriff's Office.
So let's go back to your education and your background in firearms. Tell the jury what your training and your education background is in firearms.
I have a bachelor's degree in chemistry from the University of South Florida, and I completed an 18-month structured training program at the Florida Department of Law Enforcement in the field of firearms identification.
What year did you start working at FDLE?
I began working at FDLE in 2006.
When you started working with FDLE in 2006, did you receive specialized training in order to become a crime laboratory analyst?
When I began with FDLE in 2006, I was in a different section. I started in firearms in 2009.
So in 2009 at FDLE, explain to us what training that you underwent in order to be working in the firearms section at FDLE.
The 18-month structured training program that I went through included units in firearms function and safety testing, which included assembly and disassembly of firearms in order to know how they work. I did units in microscopy of bullets, microscopy of cartridge cases, firearms history and development, ammunition history and development. I did units in serial number restoration, distance determination, and I also completed then I completed an oral board, which was essentially 3.5 hours of question after question, making sure I understood everything in the firearms section. During that time, I also completed I had to do competency tests and also had to do practicals in order to be able to complete my training. After I completed all of that, I did 6 months of supervised casework, which was then culminated with a mock trial of testimony, and then I was released to do supervised casework. I'm not supervised, my own casework.
Do you have to have an official certification in order to be completely done with all of this training to do your own casework?
I received just a completion of the training program from the Florida Department of Law Enforcement.
When you worked at FDLE in the forensic or the firearms department, approximately how many times did you have an occasion to analyze a firearm?
I did not count how many times I had an opportunity to analyze a firearm, but at this point, it's in the thousands.
When you started at HCSO, approximately how many times since you've joined HCSO have you had an occasion to analyze a firearm?
Hundreds.
Have you testified in court as a firearms expert before?
Yes, I have.
Approximately how many times?
More than 60.
Your Honor, at this time, I tender the witness as an expert in the area of firearms to...
Any questions?
No question.
All right, you can proceed.
Help us understand, we have during the course of this trial heard terms such as projectile and casing. Are those things that you analyze in your capacity as a forensic lab firearms analyst at HCSO?
Yes.
Let's start with a projectile. Walk us through what is a projectile.
A projectile is the portion, it is also called a bullet, That is the part of a cartridge that will go down the barrel of a firearm when it is fired.
What about a casing? What is a casing?
A cartridge case is the Tupperware container of the cartridge itself. It will hold the bullet at the top. The cartridge case holds inside of it the gunpowder. And at the very head stamp or the bottom of the cartridge case, you will see the primer. On the head stamp of that cartridge case is usually the brand and the caliber.
So a projectile, is that word synonymous with or the same as a bullet in layman's terms?
Yes.
You refer to the cartridge casing. We've heard the term casing. Are those two words or terms synonymous, the same thing?
Yes, I call it a cartridge case. I will hear the word casing.
Now, when you are analyzing a firearm, what is the purpose of analyzing a firearm?
When I'm looking at a firearm, I'm looking at it to see that all of the safeties are working, that there's no damage to the firearm. I want to make sure it's safe for me to fire when the time comes. Then the next step would be to test fire that firearm and obtain those test fires in order to look at those test fires to do any comparisons to any evidence of cartridge cases or bullets that I might receive.
When you receive a firearm and you are requested to test a firearm, when you're doing these test fires, is that the process of making sure the firearm is functional?
Yes.
During your inspection of the safeties that you described, is that also a part of your analysis of whether or not a firearm is actually functional?
Yes.
When you analyze a firearm to see if the safeties are working or whether or not it's functional, do you ever receive projectiles or cartridge casings as well?
Yes.
What are you an expert at doing when you have a projectile, casings, and a firearm as a forensic lab firearms analyst?
I am tasked to determine whether or not those bullets or cartridge cases were fired in or from that firearm.
I want to talk about that process in detail. When you are tasked with analyzing whether or not a cartridge casing came from a specific firearm, walk us through the process. How is that done?
Once I've test fired the firearm, I'm going to bring those test fires back, and I'm going to then look at the class characteristics that are on those cartridge cases. I'm going to document them on the firearm worksheet, and then I'm going to take out each of the evidence cartridge cases that I receive, and I'm going to document each one of those. I'm going to look to see what the class characteristics are on that particular cartridge case. So a class characteristic is something that's predetermined by the manufacturer, and it could be typical of other guns, not just that particular gun. An example would be the shape of the firing pin, the shape of the firing pin aperture, that's the hole that the firing pin sticks out of, and what type of marks I see on that cartridge case. In order for me to do that, I use a comparison microscope, which allows me to see two things at the same time at the same magnification. Now, if those class characteristics on the cartridge cases are the same class characteristics that I see on the firearm, I can then begin another part of the examination, which is called looking for the individual characteristics or the pattern of individual characteristics. The pattern of individual characteristics is unique to that firearm, and it's caused by the manufacturing process itself, and it also can come from the use, abuse, erosion, corrosion of the firearm. So when I'm looking, I want to see if those individual characteristics that I see on the cartridge case are the same individual characteristics that are on the test fire or the other cartridge cases that I have received.
That was a lot of information. Let's go back. Class characteristics. When you are test firing a firearm and, for instance, looking at the casing that comes out during the test fire, help us understand how do those class characteristics get there?
So when the firearm is fired, the cartridge case, the first thing that's going to happen is the firing pin is going to strike that primer, and it's going to leave an impression of the shape of that firing pin on the primer of the cartridge case.
If I can stop you right there, I apologize. You've used the term firing pin and primer.
Yes.
What are those, and where are they located within a firearm?
The firing pin is located inside the slide, in the center of the slide, back portion of it, in the firearm. It's the portion that will be released forward when you are ready to fire the firearm. And a primer is that circle that you see on the back of a cartridge case, and that is where the spark comes from on a cartridge.
Okay, so the firing pin and the primer, you were explaining the process of how those class characteristics get on the actual casing that is expelled. Please continue, I'm sorry.
So the firing pin will make an impression onto that primer, which will then cause an explosion. The light that, or I'm sorry, the spark that comes from the primer will ignite the gunpowder that's inside the cartridge, which in turn will make the bullet go down the barrel, but it will also force that cartridge case back against the back portion of the slide, and it will also leave marks in the on the back or the primer of that cartridge case. At that point, then the cartridge case gets expelled from the firearm.
Now, what about individual characteristics? You said the individual characteristics that are left on a cartridge casing differ, they're not the same.
From firearm to firearm.
Okay, so let's talk about a projectile, for instance. What happens to a projectile as it's going through to be ejected or fired from a firearm?
When the cartridge is ignited and the bullet goes down the barrel, the bullet will travel down the barrel and it will get class characteristics from inside the barrel, which are the rifling inside the barrel, which are those spiral grooves that you see within the interior of the barrel. Those will be imparted onto the bullet. That's a class characteristic. Multiple firearms may have the same class characteristics. At that same time, it's also getting individual characteristics imparted onto it.
Those impressions are class characteristics and individual characteristics. Is that what allows you to analyze a test fire to a projectile that's already been fired to see whether or not they match?
Yes.
Before you kind of started to describe using a microscope to compare the two, the test fire that happens in a controlled environment and the one that's actually expelled. Help us understand how you do that.
The first thing I do is I want to make sure each of those items has individual characteristics. I can't continue my examination if it does not have any individual characteristics. If it does have individual characteristics, I can compare the item of evidence to a test fire or to other items of evidence.
In this case, tell the jury, so what happens next?
If I see repeating patterns of individual characteristics on the item, then I can make identifications.
And again, you're looking at these class characteristics and individual characteristics on a test fire and a projectile provided to you under a microscope, correct?
Correct.
Now, tell us about the test firing process. When you receive a firearm and you're requested to test fire it, where do you do that?
I test fire it into the section water tank.
What does the water tank look like?
The water tank is essentially a big steel box that has a port on one end, and you'll fire the firearm into that port.
Is it just like a big open area that you aim at and fire in, or is it a defined area?
There is a small port at the front of the tank. The tank is filled with water. I aim the firearm into that port, and then the bullets will be collected from the water.
How many times do you think in your career as a firearms analyst have you done this process of firing a firearm into this water tank with this port at the front?
I haven't counted, but I would assume at this point in the thousands.
When you're test firing firearms, are they all of the same type or are they different types?
As far as the cartridge,
No, of the firearms that you're asked to fire.
I have test fired many different firearms.
Have you test fired a Glock 43 as the same as the one that was involved in this case and provided to you?
43 or 42?
42.
Yes, I have.
And for reference, I'll show you what's been entered into evidence as State Exhibit 16. I'm gonna place it in front of you. Where you provided State's Exhibit, was it 16? 16 to test fire.
May I check the box? Yes, I was.
How do you know?
I could see the case number, the exhibit number, and my initials in my handwriting on the firearm and the magazine.
Each firearm that you receive for testing, does it get an individual case number associated with it that you just explained is representative on this firearm?
It gets an individual property item number or exhibit number, and it will have a case number, and then I will write those things on the firearm or the date and my initials on them. In this case, I wrote all of that myself.
When you receive a firearm, I heard you talk about some of your training includes the assembly and disassembly of the firearm when deciding whether or not a firearm is operable. Is that correct?
Yes.
Did you do that in this case? Is that a part of your evaluation when you receive a firearm, is assembling and disassembling, disassembling and then assembling the firearm?
I test fired the firearm first, and then I did remove the slide to check the safeties.
Okay, so how many occasions have you had in your career to fire a Glock 42 specifically?
I don't have a specific number. I've fired many Glocks, though.
Do you think over 100 times in your career is safe to say, approximately?
Yes.
Now, let's talk about your understanding and your education or background in the brand of Glock. What do you know about the brand of Glock?
I did take a Glock armorer's course when I began my training at the Florida Department of Law Enforcement, and I'm very aware of how the Glock operates.
Tell us how the Glock operates. And I guess while you're explaining that, can you specify how it operates and how it may be different than other brands?
Do you want me to start of how to is essentially fire the Glock?
Sure.
In order to test fire or to fire a Glock, the first thing you need to do is to load ammunition into the magazine. That's the container that holds the cartridges so that you can fire one right after the other. The next thing you're going to need to do is take that top portion of the firearm and you're going to have to pull the slide back and release it. I'm sorry, after you've inserted the magazine into the magwell. Then you're going to take that slide back and release it. The first cartridge in that magazine will now be inserted into the chamber of the firearm, and the firearm is ready to fire. When you released that slide at the top of the firearm, at that same time, the firing pin has been slightly cocked in the firearm. That means it's been pulled back ever so slightly. Now the firearm is ready to fire. When I pull the trigger, I have to depress the trigger itself, and there's also a trigger safety on this particular firearm. I have to depress the trigger safety and the trigger at the same time in order for that firearm to fire. When I pull that trigger, the firearm will fire, the bullet will go down the barrel, the slide will move back, and the cartridge case will be extracted and ejected from the firearm. At the same time, the slide will now start moving back forward. It will take the next cartridge out of the magazine and it will load it into the chamber. And it will have now repeated the process that happened again.
On the Glock brand specifically, help us understand the safety precautions that are present on Glock firearms.
The Glock has the trigger safety, which is located on the trigger. It's in the center. It kind of protrudes a little bit from the trigger itself. It's right down the middle. You have to depress it in order for the trigger to be pulled back. The Glock also has a firing pin block safety, which in order for that firing pin block to get out of the way of the firing pin, you have to pull the trigger. And again, in order to pull the trigger, you have to depress the trigger safety. This firearm also has what is known as a drop safety. All that particular thing is doing is it's holding back that firing pin, and then it will pull it back a little bit more and then drop out of the way. And the firearm will not fire unless that has dropped out of the way.
So, for instance, with this firing pin block safety, does that help prevent things like accidental shootings?
The firing pin block safety will not allow the firing pin to go forward unless the trigger has been pulled.
The trigger safety, you've described as a small object on the middle of the trigger. If the trigger safety is depressed, but not the entire trigger behind it, will a Glock 42 fire?
If just the safety has been depressed, no, it will not fire. You have to finish pulling the trigger.
Help us understand the difference of the terms semi-automatic firearm and automatic firearm, excuse me.
A semi-automatic firearm requires a pull of the trigger for every shot that is fired. A fully automatic firearm, all you have to do is depress the trigger, and as long as there is ammunition in the magazine and you're still depressing that trigger, it will continue to fire.
The Glock 42 that we see in States 16 that's sitting on the ledge in front of you, is that a semi-automatic firearm or is that an automatic firearm?
It's a semi-automatic firearm.
Does that mean in order for the firearm to be fired multiple times, you would have to both depress the trigger safety and the trigger in its entirety multiple times in order to fire it?
Correct.
Asked in another way, does it require you to completely pull and then release it before pulling it again to continue firing it?
You will pull, and then you have to release pressure. It doesn't mean your finger's still not there. It may be putting a little pressure, but it does have to be fully extended again in order for you to pull again.
If a Glock 42 with these safety features, which you've described on the Glock 42 in front of you, were to, for instance, be dropped, would it be able to go off?
With the firing pin block safety, it would not go off.
I want to talk about the process of test firing again. You described to us the water tank that you fire into. Using your hands, can you raise your hands up and show the jury exactly how big is that, I forget what you called it, oh, the port that you fire into?
It's approximately 6 inches wide.
Approximately 6 inches wide. And is that standard for you? You've done that in every case where you've fired firearms into this water tank?
Not every firearm will get fired into the water tank, but most do.
Okay, so when you test fired this firearm into a water tank that had a 6-inch wide port, how many hands did it require you to use on the firearm to point and aim it correctly in the hole?
I use two.
Action relevance?
Overruled.
You can answer it.
I use 2 hands.
Why did you use 2 hands?
I want to make sure I'm holding the firearm firmly so it will cycle properly.
We sometimes hear in conjunction with firearms terms such as recoil. What is recoil?
Recoil is the amount of force that's going to come back at you after you have test fired a firearm or fired a firearm. It causes a little bit of force into your hand.
A Glock 42, or I guess maybe even the Glock brand in general, what is the recoil based on your training and your experience firing Glocks? What is the recoil like in firearms?
Depends on the firearm. For Glock, I do have some recoil when I'm firing the firearm. It's not the same as other firearms.
Does the recoil depend on the caliber and type of firearm?
It can.
So when you're holding a firearm and you're firing, for instance, into your water tank or you're trying to aim, how do you combat the recoil that you would experience of the firearm after it, or as it's fired, excuse me?
I am using two hands when I test fire, and then I just wait in between shots to make sure I can aim and make sure I am aimed properly into the port.
May I have just a moment, Judge?
Yes?
In this case, were you provided shell casings and projectiles in order to do a comparison after you test fired the firearm?
Yes.
Tell us about that process.
I received bullets and cartridge cases in this case, and I obtained them from the evidence section, and then I brought them back in order to compare them to my test fires of this firearm.
How many test fires did you have when you test fired this firearm?
I test fired this firearm twice.
How many do you use of the, how many of the test fires do you use when you're placing it on the microscope and you're looking at it in comparison to the ones that you're provided from the scene?
I used one bullet, one cartridge case.
Is that standard?
You could use multiple test fires if needed, or multiple bullets or cartridge cases. It depends on the scenario.
Did you need to do that in this case?
In this particular case, I did not.
Why?
They were well marked.
Okay, so you test fire it, you have a test casing and a test projectile. How many projectiles did you receive either from the scene or from the deceased?
I received 3 fired bullets and 1 fired bullet core.
Did you compare those bullets to your test fire?
I compared the fired bullets to each other and to the test fire.
What's the purpose of comparing the fired bullets to each other?
I had originally, when I was going through to see the individual characteristics, I noticed that they all had the same individual characteristics, and I could see marks that looked similar on each of them as I put each one up individually, and then I put them up together to just index them or mark them to see those patterns were the same at that point.
After you compared the test fires to each other, did you choose one and compare it to each projectile or bullet that you were provided in this case?
In this particular case, I compared the bullets to each other first, and I took one of them and I compared it to a test fire.
Why do you compare the bullets provided to you from the scene or the deceased to each other first?
In this particular case, there was no reason why I did that over looking at them to the test fire. It's just I had seen the pattern when I was looking at them individually, so I marked them at the time.
What is your expert opinion about the projectiles that you were provided associated with this case that you received from either the scene or the deceased?
I identified them to the firearm.
Are you talking the firearm in front of you, State's Exhibit 16?
Yes.
Does that mean that the projectiles that you were provided and used during your analysis came from State's Exhibit 16, the Glock 42 that's in front of you?
Yes.
What about the cartridge casings? Were you provided cartridge casings and asked to compare them in this case?
Yes.
How did you do that?
I took those cartridge cases, I looked at them each individually and made sure they had individual characteristics, and then I compared them. In this particular instance, I compared each cartridge case to a test fire.
When you compared each cartridge case that was found at the scene of this event to the test fire, tell the jury what your results were.
I determined that they were identified to the firearm here in front of me.
Does that mean that those cartridge casings were expelled from the firearm that's sitting in front of you?
Yes.
Judge, may I have just a moment?
Yes?
I don't have any further questions. I will take just one moment to return.
Cross?
Good afternoon.
Good afternoon.
Now, you were involved in doing some analysis in this case, and then later on, you were asked to do some additional analysis more recently.
That is correct.
And that was based on the retirement of one of the FDLE examiners that was involved in the case, Mr. Kwong.
That's what I'm assuming, yes.
Okay. But you had originally done some test fires in the case and did an examination of the firearm.
That is correct.
So then later, when you were asked to continue to review the case or review the rest of the evidence, you were able to use those original test fires that you used in this case.
That is correct.
And you were able to identify those casings to each other and to the firearm in this case.
In this particular case, I ID'd each cartridge case back to a test fire.
Okay, and that test fire was from this firearm that you were shown a minute ago.
Yes.
When you looked at the ammunition, there was two types of ammunition, right, from the casings?
Correct.
And what were the types of ammunition?
There were two types, Hornady and Norma.
Okay, and both of those are obviously 380.
Correct.
Now, Ms. Reeder was asking you about the safety features on the Glock, on the firearm in this case, and you said that there's the trigger and the trigger safety, and then there's the firing pin block safety, correct?
There's the trigger safety, the firing pin block safety, and the drop safety.
Okay. All of those, as you pull back the trigger, will go along and allow you to fire the gun.
That is correct.
It's not something that you have to do separately. It all kind of goes together as you pull the trigger.
Correct. As you're depressing the trigger along with that trigger safety, and you pull the trigger all the way back, it will disengage the firing pin block safety, allowing that firing pin to flow through the channel.
Adults could fire this firearm, correct?
I would assume so.
Okay, and children could fire this type of firearm.
I can't determine whether or not anybody particularly could fire a firearm, but is it possible? Yes.
Okay. And in fact, you're able to test for trigger pull. Is that correct?
I do have a way of measuring trigger pull, yes.
But in this case, you did not do that.
No.
And that would tell you the force needed to pull the trigger with this particular firearm.
That is correct.
When you did do the test fires, you didn't find anything unique about this firearm versus any other kind of Glock that you've used before.
The trigger pull didn't seem any different than any other Glock that I've fired.
And typically, you've stated that the trigger pull for a firearm is about like opening a can of soda.
Correct.
Nothing further.
Anything else?
No, Judge.
All right, you can step down, ma'am, thank you. She released from her subpoena?
No, Judge.
All right, free to go. She's released, right?
Yes, Your Honor.
All right. Call your next witness.
Judge, we have a stipulation that we'd ask the court to read.
All right.
this time.
All right, so the parties have stipulated to an additional fact. The state of Florida and the defendant Shirley Bass stipulate to the following. The person who died on the 29th day of August 2022 has been identified as Jayla Bass, the individual named in counts 1 and 2 of the indictment in this cause. We're hereby certify the foregoing stipulation is made in good faith for the reasons alleged here and dated the 26th day of February 2025, signed by Mr. Terry, Ms. Schlemmer, and the defendant, Mr. Bass. And it's commonly called the stipulation as to identity, and that the parties are not contesting the identity of the individual that died and the autopsy was performed upon in this case. Go. All right,
Your Honor, this time the state rests.
the state rests. All right, we will take a recess at this time. All rise.
Judge, at this point, the defense, we renew all previous motions and objections, specifically our motion to suppress Mr. Bass's statements that were made to law enforcement prior to being read Miranda. We'll move for a judgment of acquittal as to the entire indictment and specifically draw the court's attention to the issue of premeditation and the premeditated murder. I provided the court in the state 2 cases, Bertram, B-U-R-T-T-R-A-M, v. State, and that's found at 780 Southern 2nd, 224. That's a 2nd District of Appeal case. And Tillman, T-I-L-L-M-A-N, v. State, and that is at 842 Southern 2nd, 922. Both talk about the standard related to premeditation. While premeditation may be proven by circumstantial evidence, the evidence relied upon by the state must be inconsistent with every other reasonable inference. Where the state's proof fails to exclude a reasonable hypothesis that the homicide occurred other than by premeditated design, a verdict of first-degree murder cannot be sustained. Related to the events in this case, there's been really no testimony put forward as to any kind of marital discord or any issues between Mr. Bass and either of his children prior to August 29th, 2022. The only evidence, frankly, about what happened at that scene comes from crime scene, the ballistics, DNA, and the brief statement made by my client to law enforcement saying that he was cleaning the gun and the gun went off. There are some additional statements from Shirley Bass on the 911 call, also talking briefly about the gun being cleaned, and at one point even saying that her son was supposed to be awake and he was running. There's been no testimony as to any kind of issues going on that would cause Mr. Bass to injure or kill or attempt to kill his children in this case. There's been no testimony as to when he became armed. There's no eyewitness testimony from any other witnesses about what happened inside of that room. We're just relying on those 2 brief statements. The evidence in the case also shows that not only was my client's DNA on the firearm, but his son's DNA was on the trigger and grip as well. And based on all of those issues, as well as the testimony that's been put forward, we would move for a judgment of acquittal as to all counts.
Mr. Terry?
Your Honor, both these cases are very distinguishable from our situation at hand. We had, in Bertram's case, it's a one shot, but I think both of these are just one shots. Here we have 5 shots directed at the victims, at least 4 we know of for sure, into the victim's head. 3 of them into Shirley Bass's head were all centrally located to the head. It's clear evidence of premeditation, the number of shots, the location of the shots, the fact that these children were helpless and defenseless laying in their bed. And the defendant admitted to being the person who shot and gave an excuse as to it being an accident. However, I believe the state has put forth evidence that this could not have occurred as an accident. And the defendant acknowledging that we do not have to prove motive in this case. And I think just the manner of the shots and the defendant's obvious lie is basis enough to argue premeditation.
All right. Anything else from the defense?
No, Your Honor.
All right, the motion for judgment of acquittal is denied. All right, what says the defense as to witnesses?
Can we have a minute?
Pardon?
May I have a moment?
Of course.
Discussing that with Ms. Brown.
Yep. I understand there's very limited evidence, but the state can argue there's no evidence of that. It's one less thing to worry about. And I'm just formatting it to make sure that there's no titles at the end of a page without some words after it, but. I've added third-degree felony murder as a lesser of count one. And then make sure you look at the verdict form.
I don't know if it matters to you guys, but the heading for 7.2 is not centered.
I know, but I can't, I don't know what. It's Mr. Terry's fault. Something that he gave me won't turn off the,
I had the same problem, Judge, with a couple of things. That's
I
why
know,
had to
I don't
do
know
that.
how to unturn off his margins when I put it in mine, so I'm just leaving it looking like I don't know how to format a document. So I obviously do not.
Judge, there's on 7.2,
Hang on one second, let me
Sorry.
get there. Yeah,
we're missing those two paragraphs under the act.
The definition of what premeditation is.
oh, I put it at the front, that's why.
Okay. That is in the front.
I put it in the definition page,
Okay. Okay.
I got it.
because it occurred like 3 times, so
Okay.
Okay. Thank you.
you're welcome. So they get it at the beginning, and then when I say it, they can refer back.
child abuse. There's just a D missing under paragraph B. The defendant is guilty of aggravated battery.
Okay.
Yes, Your Honor.
State?
Yes, Judge.
Do you want a clean copy of the instructions to use for closing for anything?
Ladies and gentlemen, when the jury comes back in, we're supposed to have the judges, read jury instructions. I think they're about 30 minutes, so if you read jury instructions, don't in and out. You need to go to this restroom, go now, or you want to stay outside, which you know.
Okay, and I'm gonna send this to you. Can you make me one yellow copy and two white copies? And then all the witnesses that were, kept on standby have been released?
Yes, Your Honor.
You had a couple that were still on standby or that we didn't release. Can you just make sure they're released?
Yes,
In case anyone wanted to come back into the courtroom or not.
I got your email, but I didn't get your attachment.
Okay, let me, it should be coming any
Oh,
second.
okay.
Usually takes a second, I don't know why.
I got the email to make the copies, but
You got an email what?
I have the email that you sent, but there was no.
Attachment? Then I just resent it with an attachment, cause I
You
forgot.
just resent, oh,
Yep.
okay. I haven't got it yet.
How long do you think you'll take in closings?
I'm sorry?
How long do you think you'll take in closings? Just speculative.
I mean, Judge, she says 45 minutes, and I might have 30 to 45 in mind, so.
All right.
That's on the higher end, I don't know.
Are you still printing?
I got the yellow one.
Okay,
I got the yellow one.
Gotcha.
The two white copies.
yeah, just for
Yeah, I
them.
printed the other one. I
Thank
don't know
you.
why my settings didn't print at the same time.
No problem. Thank you. There's 11. You can put them on the back row.
Do it all sometime. Long walks. Over to James, you start lining them up. Instructions send them home.
Huh?
Instructions send them home. Close the video.
No, I'm gonna send them out.
Cut it for punishment.
I'll ask them. Stating you're about to arrest.
Yes, we'll renew our prior motion for judgment of acquittal and all of our prior objections and motions. Same argument.
All right, same rulings.
And the rest on the record. Do we have a second while you're still making copies?
Yeah,
Something
we're,
on the record?
Andrew's printing it, I think. The two white, oh, that's for them.
Oh,
As I discussed with Mr. Terry an issue, I just wanted to make sure that there wasn't a specific reason that Ms. Bass was not going to testify.
That what?
That
Oh,
Ms. Bass was not going to testify, like she changed her story
Right.
and prep, like a Brady or Giglio issue. I have discussed it with Mr. Terry. I do believe he's making a strategic decision. He has advised me there weren't any different statements. but I just wanted to make sure that the record was clear for that.
All right.
What we discussed.
Sure.
And by not different statements, not different than you've heard
Correct.
a couple of varieties of statements, but
Right.
something
And
new from what we've already
she's
heard.
here, and you're certainly welcome to talk to her if that would affect your ability about whether or not you wanted to call her too, so, all right.
Thank you, Judge.
Emily, do you need that? I need that. Yes.
What?
13. Why don't you just give them to them as they walk in? There you go. All right, have a seat. State having rested, what says the defense?
The defense at this time will rest, Your Honor.
All right, so both the state and the defense have rested their cases. As I warned you, now is my opportunity to instruct you on the law. As I also told you, you each have your own set of written instructions that have been just handed out to you, so you can use these. It's not a history test or a civics test. You don't have to remember everything I've said, so you'll have each of these copies to use during the arguments of the lawyers and/or during deliberations as you should see fit. I am required by law, though, to read them aloud to you. So those of you who are visual learners are welcome to read along with me. Those of you who would like to be read to may be read to. Either way, I just ask you to pay attention to the instructions. All right, Jermaine Lavonda Bass, the defendant in this case, has been accused of the crimes of first-degree murder and 2 counts of aggravated child abuse and 1 count of attempted first-degree murder. Here's some definitions that will apply throughout these instructions. A weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or any other object that was used or threatened to be used to inflict bodily harm. A deadly weapon or a dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. A firearm is any weapon which is designed to or may readily be converted to expel a projectile by the action of an explosive. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. Willfully means intentionally and purposely. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. In considering the evidence in this case, you should consider the possibility that although the evidence may not convince you the defendant committed the main crimes of which he is accused, there may be evidence he committed other acts that would constitute what's called a lesser included crime. Therefore, if you decide the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes included in the definition of first-degree murder are second-degree murder, third-degree felony murder, and manslaughter. The lesser crime included in the definition of aggravated child abuse is aggravated battery. The lesser crimes included in the definition of attempted first-degree murder are attempted second-degree murder and attempted manslaughter. Mr. Bass is accused of first-degree murder. First-degree murder includes the lesser crimes of second-degree murder, third-degree felony murder, and manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Jayla Bass was killed by Jermaine Lavonda Bass, you will then consider the circumstances surrounding the killing and deciding if the killing was first-degree murder or any lesser included that should be offense, or whether the killing was excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances: when the killing is committed by accident and misfortune, in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent; or when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation; or when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. I'll now instruct you on the circumstances that must be proved before Jermaine Bass may be found guilty of first-degree premeditated murder or any lesser included crime. There are two ways a person may commit first-degree murder. One is known as first-degree premeditated murder, and the other is known as first-degree felony murder. To prove the crime of first-degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. 1, Jayla Bass is dead. 2, the death was caused by the criminal act of Jermaine Bass. And 3, there was a premeditated killing of Jayla Bass. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An issue in this case may be whether Jermaine Bass did not act with a premeditated design to kill because he acted in the heat of passion based on adequate provocation. In order to find the defendant did not act with a premeditated intent to kill because he acted in the heat of passion based on adequate provocation, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person. And a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury. And there was not a reasonable amount of time for a reasonable person to cool off. And a reasonable person would not have cooled off before committing the act that caused death. And Jermaine Bass was, in fact, so provoked and did not cool off because he committed the act that caused the death of Jayla Bass. If you have a reasonable doubt about whether the defendant acted with a premeditated design to kill because he acted in the heat of passion based on adequate provocation, you should find him not guilty of the charge of first-degree premeditated murder. To prove the other way you can prove first-degree murder, first-degree felony murder, the state must prove the following three elements beyond a reasonable doubt. 1, Jayla Bass is dead. 2, while engaged in the commission of an aggravated child abuse on either Jayla Bass or Jermaine Bass in counts 2 and 3, or any lesser charge on those counts, Jermaine Lavonda Bass caused the death of Jayla Bass. Or, while engaged in the attempt to commit first-degree murder on Jermaine Bass in count 4, or any lesser charge, Jermaine LaVonda Bass caused the death of Jayla Bass. And 3, Jermaine Bass was the person who actually killed Jayla Bass. In order to convict the defendant of first-degree felony murder, it is not necessary for the state to prove the defendant had a premeditated design or intent to kill. To prove the lesser included offense of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Jayla Bass is dead. 2, the death was caused by the criminal act of Jermaine Bass. And 3, there was an unlawful killing of Jayla Bass by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose, and an act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and is done from ill will, hatred, spite, or an evil intent, and is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. An issue in this case is whether Jermaine Bass did not have a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation. And again, in order to find the defendant did not have a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person, and a reasonable person would have lost normal self-control or would have been driven by a blind and unreasoning fury, and there was not a reasonable amount of time for a reasonable person to cool off, and a reasonable person would not have cooled off before committing the act that caused death, and Jermaine Bass was in fact so provoked and did not cool off before he committed the act that caused the death of Jayla Bass. If you do have a reasonable doubt about whether the defendant had a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation, you should find him not guilty of the charge of second-degree murder. To prove the lesser crime of third-degree felony murder, the state must prove the following beyond a reasonable doubt. 1, Jayla Bass is dead, and 2, her death occurred as a consequence of and while Jermaine LaVonda Bass was engaged in the commission of the felony lesser offense of aggravated battery, and Jermaine Bass is the person who actually killed Jayla Bass. In order to convict of third-degree felony murder, it is not necessary for the state to prove the defendant had a premeditated design or intent to kill. The lesser offense of aggravated battery for the purpose of this instruction is defined in instruction 8.4 in the following instructions. See also instruction 3.12D, interlocking counts, that we'll get to in a minute as it pertains to this lesser offense. To prove the lesser included offense in count 1 of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. 1, Jayla Bass is dead. 2, Jermaine LaVonda Bass intentionally committed an act or acts that caused the death of Jayla Bass, or the death of Jayla Bass was caused by the culpable negligence of Jermaine Bass. Every person has a duty to act reasonably toward others. If there's a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which did cause death. I'll now define culpable negligence for you. As I've said, every person has a duty to act reasonably toward others, and a violation of that duty without conscious intention to harm is negligence. But culpable negligence is more than a failure to use ordinary care toward others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. To prove the crime of aggravated child abuse for counts 2 and 3, the state must prove the following two elements beyond a reasonable doubt. One, Jermaine Bass committed an aggravated battery upon Jayla Bass in count 2, or Jermaine Bass for count 3. And 2, Jayla Bass in count 2, or Jermaine Bass in count 3, was under the age of 18 years. In order to prove that an aggravated battery was committed, the state must prove the following two elements. The first element is a definition of battery. 1, Jermaine Bass actually and intentionally caused bodily harm to Jayla Bass in count 2, or Jermaine Bass in count 3. And 2, in doing so, Jermaine Bass intentionally or knowingly caused great bodily harm. It is not a crime for a parent of a child to impose reasonable physical discipline on a child for misbehavior under the circumstances, even though physical injury resulted from the discipline. To prove the lesser included crime of aggravated battery for counts 2 and 3, the state must prove the following two elements beyond a reasonable doubt. And the first element is a definition of battery. 1, Jermaine Bass intentionally caused bodily harm to Jayla Bass in count 2, or Jermaine Bass in count 3. And 2, Jermaine Bass in committing the battery intentionally or knowingly caused great bodily harm to the victim. For count 4, in order, Jermaine Bass is accused of attempted first-degree murder. Attempted first-degree murder includes the lesser crime of attempted second-degree murder and attempted manslaughter, all of which are forms of attempted homicide, and all of which are unlawful. However, an attempted homicide that was excusable or was committed by the justifiable use of deadly force is lawful. If you find there was an attempted homicide of Jermaine Bass by Jermaine Lavonda Bass, you will then consider the circumstances surrounding the attempted homicide in deciding whether it was attempted first-degree murder or attempted second-degree murder or attempted manslaughter, or whether the attempted homicide was excusable or resulted from the justifiable use of deadly force. An attempted homicide is justifiable and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. An attempted homicide is excusable and therefore lawful under any one of the following three circumstances. When the attempted homicide is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent, or when the attempted homicide occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation, or when the attempted homicide is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the attempted killing is not done in a cruel or unusual manner. I'll now instruct you on the circumstances that must be proved before Jermaine Lavonda Bass may be found guilty of attempted first-degree murder or attempted second-degree murder or attempted manslaughter by act. To prove the crime of attempted first-degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. 1, Jermaine Lavonda Bass intended to commit the crime of first-degree premeditated murder. And 2, he committed an overt act toward the commission of first-degree premeditated murder that went beyond mere preparation. And 3, Jermaine Bass failed to complete the first-degree premeditated murder. The line between mere preparation and an overt act is a question of fact for you to decide. Mere preparation consists of devising or arranging the means or measures necessary to commit the crime. An overt act consists of some movement toward committing the crime after mere preparation. An overt act need not be the last possible act toward completing the crime. To prove that a first-degree premeditated murder had taken place, the state would have had to prove the following three elements beyond a reasonable doubt. 1, Jermaine Bass is dead. 2, the death was caused by the criminal act of Jermaine LaVonda Bass. And 3, there was a premeditated killing of Jermaine Bass. To prove the crime of attempted second-degree murder, a lesser-included offense of count 4, the state must prove the following three elements beyond a reasonable doubt. 1, Jermaine LaVonda Bass intentionally committed an overt act that could have resulted in the death of Jermaine Bass, but did not result in Jermaine Bass's death. And 2, that act was eminently dangerous to another and demonstrating a depraved mind without regard for human life. And 3, the overt act went beyond mere preparation. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and is done from ill will, hatred, spite, or an evil intent, and is of such a nature that the act itself indicates an indifference to human life. The line between mere preparation and overt act, again, is a question of fact for you to decide. Mere preparation consists of devising or arranging the means or measures necessary to commit the crime. An overt act consists of some movement toward committing the crime after mere preparation. An overt act need not be the last possible act toward completing the crime. To convict the defendant of attempted second-degree murder, it is not necessary for the state to prove the defendant had any intent to cause death. To prove the lesser-included crime in count 4 of attempted manslaughter by act, the state must prove the following two elements beyond a reasonable doubt. Jermaine LaVonda Bass intentionally committed an overt act that could have resulted in the death of Jermaine Bass, but did not result in Jermaine Bass's death. And 2, the overt act went beyond mere preparation. And again, the line between mere preparation and overt act is a question of fact for you to decide, and we've defined that before 2 times already. The defendant cannot be guilty of attempted manslaughter by act by committing a merely negligent act. Again, every person has a duty to act reasonably and use ordinary caution toward others. If there is a violation of that duty without any conscious intention to harm, that violation would be negligence. To convict of attempted manslaughter by act, it is not necessary for the state to prove the defendant had an intent to cause death, only an intent to commit an act that could have caused death and was not justifiable or excusable attempted homicide, as I previously instructed you. If you do find Jermaine LaVonda Bass committed first-degree murder, second-degree murder, third-degree felony murder, or manslaughter, or attempted first-degree murder, attempted second-degree murder, or attempted manslaughter, you will then be asked to determine whether the state has proven beyond a reasonable doubt he personally carried, displayed, used, threatened to use, or attempted to use any weapon or firearm. If you find he committed first-degree murder or second-degree murder, third-degree felony murder, attempted first-degree murder, attempted second-degree murder, or aggravated child abuse, you will also be asked to determine whether the state proved beyond a reasonable doubt that during the commission of that offense, he actually possessed a firearm, whether he discharged that firearm, and whether that discharge caused death or great bodily harm. To actually possess a firearm means the defendant carried a firearm on his person or had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. Mr. Bass has entered a plea of not guilty. This means you must presume or believe he is innocent. This presumption of innocence stays with him as to each material allegation in the charging document through each stage of this trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome his presumption of innocence, the state has the burden of proving the crime with which he is charged was committed and that he is the person who committed that crime. Mr. Bass is not required to present evidence or to prove anything. Wherever the phrase reasonable doubt is used, you must consider the following. A reasonable doubt is not a mere possible doubt or a speculative, imaginary, or a forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of his guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction of his guilt, or if you have a conviction of his guilt, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find him not guilty because that doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you're to look for that proof. A reasonable doubt as to the guilt of Jermaine Bass may arise from the evidence, from conflicts in the evidence, or from a lack of evidence. If you have a reasonable doubt, you should find him not guilty. If you have no reasonable doubt, then you should find him guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are as follows. Did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Did the witness's testimony agree with other testimony and other evidence in the case? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in the courtroom? The evidence that a witness may have made a prior statement that is inconsistent with his or her testimony in court should be considered only for the purpose of weighing the credibility of that witness's testimony and should not be considered as evidence or proof of the truth of the prior statement or for any other purpose. Had the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The fact that a witness is employed in law enforcement does not mean his or her testimony deserves more or less consideration than that of any other witness. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. Whether the state has met its burden of proof does not depend on the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of evidence presented. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against Jermaine Bass. It is not necessary for him to disprove anything, nor is he required to prove his innocence. It is up to the state to prove his guilt by evidence. Mr. Bass has exercised a fundamental right by choosing not to be a witness. You must not view this as an admission of guilt or be influenced in any way by this decision. No juror should ever be concerned that he did or did not testify at trial. Statements claimed to have been made by Jermaine Bass outside of court were testified to in this trial. Any such statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence whether the alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to, whether when he made the statement, he had been threatened in order to get him to make it, and whether anyone had promised him anything in order to get him to make it. If you conclude that any out-of-court statement was not freely and voluntarily made, you should disregard it. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. First, you must follow the law as it is set out in these instructions. If you failed to follow the law, your verdict would be a miscarriage of justice. There's no reason for failing to follow the law. Everyone is depending upon you to make a wise and legal decision in this case. This case must be decided only on the evidence you've heard from the testimony of the witnesses, have seen in the form of exhibits and evidence, and based on these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or because you are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in any way. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is then my responsibility to determine a proper sentence if he is indeed found guilty. Whatever verdict you render must be unanimous, which means each juror must agree to the same verdict. In reaching your verdict, do not let bias, sympathy, prejudice, public opinion, or any other sentiment for or against any party influence your decision in any way. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your responsibility. I cannot participate in that decision in any way. So please disregard anything I may have said or done or any ruling that I've made that make you think I prefer one verdict over another. You may find Mr. Bass guilty as charged in the charging document or guilty of such lesser offense as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count, which was proved beyond a reasonable doubt. If you find no offense was proved beyond a reasonable doubt, then of course your verdict must be not guilty. If you do return a verdict of guilty to the charge of first-degree murder, it is not necessary that all of you agree the state proved first-degree premeditated murder, and it is not necessary all of you agree the state proved first-degree felony murder. Instead, what is required is that all of you agree the state proved either first-degree felony murder or first-degree premeditated murder. You will be asked to choose as to each theory of first-degree murder whether or not you are unanimous as to that theory. A separate crime is charged in each count of this charging document, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one count, but must not necessarily affect your verdict as to any other count charged, except as follows. Legally interlocking counts, and this describes the first-degree felony murder count in count 1 and counts 2, 3, and 4. So first-degree felony murder in count 1 and aggravated child abuse in counts 2 and 3, or attempted first-degree murder or attempted second-degree murder in count 4 are linked in that the aggravated child abuse or the attempted first-degree or attempted second-degree murder is an essential element of first-degree felony murder. So you should consider the evidence applicable to the aggravated child abuse charge and the attempted first-degree and attempted second-degree murder charge. If you find that the aggravated child abuse charge or the attempted first or second-degree murder charge has not been proved beyond a reasonable doubt, then you must find Jermaine Bass not guilty under the theory of first-degree felony murder in count 1. But you can still consider whether first-degree murder under the theory of premeditation or a lesser offense of second-degree murder or of manslaughter have still been proven beyond a reasonable doubt as to count 1, and if so, return a verdict of guilty for that offense. If, on the other hand, you do find aggravated child abuse charge or the attempted first or attempted second-degree murder has been proved beyond any reasonable doubt, you can there and must then consider the evidence applicable to the theory of first-degree felony murder. A guilty verdict for aggravated child abuse or for attempted first-degree or attempted second-degree murder does not require a guilty verdict under the theory of first-degree felony murder. You may find him guilty under the theory of first-degree felony murder only if you find all the elements of that crime including the essential elements of aggravated child abuse or of attempted first-degree or second-degree murder, were proved beyond a reasonable doubt. Additionally, count 1 lesser offense of third-degree felony murder and count 2 and 3 lesser offense of aggravated battery are also linked, and that the aggravated battery in count 2 and 3 are linked to as being an essential element of third-degree felony murder in count 1. So, you should first consider the evidence applicable to the lesser offense of aggravated battery. If you find the aggravated battery has not been proved beyond a reasonable doubt, then you cannot find him guilty of third-degree felony murder. But you may consider whether different lesser offenses of second-degree murder or of manslaughter have still been proven beyond a reasonable doubt, and if so, return a guilty verdict for that lesser offense. If, on the other hand, you find that the lesser offense of aggravated battery has been proved beyond a reasonable doubt, you must then consider the evidence applicable to the third-degree felony murder. A guilty verdict for aggravated battery does not require a guilty verdict for third-degree felony murder in count 1. You may find him guilty of third-degree felony murder, the lesser offense in count 1, only if you find all the elements of that crime, including the essential elements of aggravated battery, were proved beyond a reasonable doubt. Only one verdict may be returned as to each count, and each of you must agree to the same verdict. The verdict must also be in writing, and for your convenience, we prepared the verdict form for you. And if you'll flip over to page 20, we're going to go over that together just so there are no questions. You'll see on page 20, we, the jury, find as follows as to count 1, murder in the first degree. You check only one letter, A, B, C, D, or E, and answer any questions under the lettered selection. So A, the defendant is guilty of murder in the first degree of Shirley Bass as charged. And if you select A, you must answer each of these following questions. 1, did the defendant personally carry, display, use, threaten, or attempted to use any weapon or firearm? Yes or no? Did the defendant actually possess a firearm? Yes or no? Did the defendant discharge the firearm? Yes or no? Did the discharge cause the death of the victim? Yes or no? 5, you must fill in a number. Blank of the 12 of us find the killing was premeditated murder. 6, blank of the 12 of us find the killing was felony murder based upon a guilty verdict of aggravated child abuse on counts 2 and 3, or a guilty verdict of any degree of attempted homicide on count 4. And 7, blank of the 12 of us find the killing was premeditated murder and felony murder. Or B, the defendant is guilty of the lesser offense of murder in the second degree, a lesser included offense. If you select B, you must answer those first 4 questions, either yes or no. Or C, the defendant is guilty of felony murder in the third degree, a lesser included offense. If you select C, you have those first 4 questions to again answer yes or no. Or D, the defendant is guilty of manslaughter, a lesser included offense. And if so, you answer that first question, yes or no. Or E, the defendant is not guilty. For counts 2 and 3, those are the same. We, jury, find as follows as to count 2. That's the aggravated child abuse of Shirley Bass. A, the defendant is guilty of aggravated child abuse as charged. B, the defendant is guilty of aggravated battery, great bodily harm, a lesser included offense. Or C, the defendant is not guilty. Those same 3 findings under we, the jury, find as follows as to count 3, the aggravated child abuse of Jermaine or JJ Bass. And on the last page, page 22, we, the jury, find as follows as to count 4. That's the attempted murder in the first degree of Jermaine JJ Bass. Again, you answer only one letter, A, B, C, or D. If you select any of those letters, if there are questions under them, you must answer each one yes or no. A, the defendant is guilty of attempted murder in the first degree of Jermaine J.J. Bass as charged. You must answer 1, did the defendant personally carry, display, use, threaten, or attempted to use a weapon or firearm? Yes or no. Did the defendant actually possess a firearm? Yes or no. Did the defendant discharge the firearm? Yes or no. Did the discharge cause great bodily harm to the victim? I see I left out the yes or no, so I'll add that before I finalize this verdict form. And then B, attempted murder in the second degree, a lesser included offense, those same 4 questions to answer. C, the defendant is guilty of manslaughter, a lesser included offense, that first question to answer. And, or D, the defendant is not guilty. There's also a place for the foreperson to both sign and print his or her name and date the verdict form. So at this time, I'm going to turn it over to the lawyers to give their final arguments to you. I'm just going to remind you of a couple of things. One, the lawyers are not witnesses, so what they say is not testimonial evidence. So if their recitation of the facts differs from your recollection of the facts, I'm going to ask you to rely on your own memories. That's why you've been chosen as jurors in the first place. Both sides have equal time to address you, but because the state has the burden of proof, they're entitled to go both first and last in their remarks to you. The state prepared to make a final argument.
Yes, Judge, but may we approach first real quick regarding
Sure.
one of the verdicts, or one of them?
Yeah.
Members of the jury, we end right where we began. It was an accidental discharge. I was trying to take the magazine out and it went off. They was both in bed. I was in their room. Those were the statements of the defendant, Jermaine Bass Jr. Mere minutes after he murdered his daughter while she was laying in the top bunk of her bed. Those were his statements as he was holding his son, who was profusely bleeding from a gunshot wound to the side of his head that he caused. It was an accident. I was loading the magazine. I was in their room. Those statements you heard on the body-worn camera of Adam Rahman, an HCSO deputy who first responded. I want to draw your attention on that same body-worn camera to the timestamp of 22:46:20, right after he made these statements. The defendant was asked, "What happened upstairs?" He looked straight at the deputies and he said, "Nothing happened upstairs." That man uttered those words, "Nothing happened upstairs," when he knew that his daughter was on that top bunk with a gunshot wound to the middle of her forehead, and she was bleeding out and she was about to die. He said nothing happened upstairs. He didn't beg them to go save her. He didn't beg them to help her. He said nothing happened upstairs. We end right where we began. Right where we began. Where defense counsel in their opening statement to you said, my client did not shoot Shirley Bass or JJ. We know that's not true. We know he did it. We know the forensic evidence points to him. And I want you to recall when our blood spatter expert was on the stand. She said to you, the scene will guide you to collect the evidence that is relevant so that you can piece together what happened. And members of the jury, that's exactly what happened throughout the duration of this trial. The testimony and evidence are pieces that, when laid together, form an arrow that point to the guilt of only one person in this case. The defendant murdered his 5-year-old daughter as she was sleeping, and he tried to murder his 8-year-old son, JJ. Remember this last Friday during jury selection, you were taught that the state has the burden to prove the elements of the crimes charged beyond a reasonable doubt. The judge explained that to you, and in fact, she just read it in this packet. It helps to know what the elements are, what we're focusing on as we go through discussing how and why we know the defendant is guilty of each element of each crime charged in this case. We'll go one by one. First degree premeditated murder. To prove the crime of first degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. Shirley Bass is dead. Number 2, the death was caused by the criminal act of Jermaine LaVonda Bass. And number 3, there was a premeditated killing of Shirley Bass. He's also charged with 2 counts of aggravated child abuse. There we talk about number 1, Jermaine LaVonda Bass committed aggravated battery upon Jayla Bass or Jermaine Bass. That's counts 2 and 3. Jayla Bass or Jermaine Bass were under the age of 18. We know that. Jermaine LaVonda Bass actually and intentionally caused bodily harm to Jayla Bass or Jermaine Bass, counts 2 and 3. In doing so, Jermaine LaVonda Bass intentionally or knowingly caused great bodily harm. We know that as well. You saw the gunshot wounds. The last count he's charged with is count 4, premeditated murder. Jermaine LaVonda Bass intended to commit the crime of first degree premeditated murder. Number 2, Jermaine LaVonda Bass committed an overt act toward the commission of first degree premeditated murder that went beyond mere preparation. Number 3, Jermaine LaVonda Bass failed to complete the first degree premeditated murder. Let's talk about how and why we know the defendant is the one who pulled the trigger. And let's talk about how and why we know that he did it intentionally. We know that the defendant started out his night by leaving his 5-year-old and his 7-year-old home alone in their beds. We know that's true. 5 and 7 home alone at nighttime. We know that he followed his wife Shirley to her family dinner in the West Shore area at Ruth's Chris restaurant. How do we know that? States Exhibit 21. We can track his cell phone records. He leaves the children home alone by at least 7:15 p.m. We know that's true because of the video surveillance shows him leaving before that time. We know that Shirley got to dinner and that the defendant arrived in the West Shore area where Ruth's Chris is located. And around 10 o'clock, we know that he's calling Shirley and he's leaving by 10:01. We heard testimony from Shirley's niece, who's kind of more like a cousin, they're similar in age, China Gadsden. She explained to you what she saw that night. She saw the defendant in his Nissan truck pull in front of Shirley's car that she was driving, stop, get out, walk up to the vehicle, and confront Shirley for going to a family dinner. We know he immediately got back in his car and went to his house. That's what States 21 shows through his phone records. We know that's true. Just like Anna Cox said, the evidence will reveal to you what happened. Other evidence that reveals this in fact is true, that the defendant followed Shirley to her dinner and confronted her, is the Eye on Crime camera video footage that we see of the defendant's car. We can read between the lines of the evidence we have as to the way the defendant was feeling at the time he arrived back home and went inside where 5-year-old Shirley Bass was sleeping in the top bunk and 8-year-old Jermaine Bass, JJ, is laying right next to her. Now again, the scene will reveal itself. We only have to follow it. We know that the children were in the bed together. Laying side by side. In the bed. I'm putting up States 24A because the forensic evidence tells us so. We know that Shirley Bass was laying closest to the wall, her head where this pooling of blood is seen, and that JJ's head was right next to her, either touching the mattress or slightly above, at the point in time that the firearm was pointed at their heads and the trigger was pulled. Remember last Friday when we discussed premeditation, Mr. Terry was talking to you about there's no specific time frame when you're trying to decide whether or not an act was premeditated. It can happen in an instant. Recall that today, Hillsborough County Sheriff's Office firearm expert Jennifer Michaelon took the stand and explained to you what would have to take place in order for that Glock 42 to fire. She explained you first have to take the magazine, you have to load it with bullets. you have to put that filled magazine inside the bottom well of the firearm. You then have to slide the top of the firearm back in order for it to fire. Then, like she explained, when she's firing these firearms regularly during the course of her investigations as a firearm expert, she uses 2 hands to be able to safely and precisely point and aim within a 6-inch area. Loading the magazine with bullets, putting the magazine inside of the firearm, sliding the top back to make it ready. And then she further explained, not only do you have to point it and aim it, each time you pull the trigger, you have to pull it hard enough to first compress the trigger pull, safety, and then the trigger itself. And she explained to you that because it is not an automatic firearm, that each time you pull the trigger, you have to pull it and let it go, and 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 pull it and let it go. And members of the jury, that evidence is the scene itself, the evidence revealing to you what premeditation is. All of those steps is the scene revealing to you through evidence what premeditation is. Look at the bullet holes. On these precious children's face. Look at them.
Objection, Your Honor, improper
Sustained.
argument. I would
Look.
ask the jury be disregarded.
Right. The jury's to disregard the last statement by the prosecutor. Let's talk about the facts.
Look where the bullet holes are located on Jayla Bass's head. Those are aimed, precise, deliberate bullet holes. That is not an accident. That is not loading the firearm and it going off. Those are aimed, precise, deliberate shots. Shots that require some sort of control over the firearm. Shot through her cheek, her temple, and her forehead. Jennifer Michaelon says that shots that are within 6 inches of one another require her to use 2 hands to shoot. This is the shot on the son, JJ's head. Now, recall he's laying right next to his sister in the bed, the top bunk. We don't know what order they were shot, but consider the proximity when deciding how deliberate these shots are. Consider the proximity when deciding how precise they are. That is the evidence revealing to you premeditation, intent and deliberate shots. Shots that are aimed at the most crucial part of a human being's body. Recall, the scene will reveal to you the evidence necessary for you to come to a conclusion as to what happened. We know from the defendant's wallet that was seized, states 15. Recall that this wallet was taken directly found in a closed drawer within a wallet that was right next to the firearm used to murder Jayla and Jake, an attempt to murder JJ, and right next to ammunition found. Note on this, height, Jermaine Lavonda Bass Jr., 5'7". Why is that important? Let's consider the trajectory of the fires shot that killed Jayla Bass and almost killed JJ. We know that the children were laying next to each other. We know that the blood shown in the pulling of this photo of the top mattress belongs to Jayla Bass because of DNA. Consider the trajectory of the bullets you see. Knowing the bunk bed is, topmost portion of the bunk bed is 5 feet 5 inches tall. The defendant is taller than that. We know that damage A is at a downward trajectory, meaning that when the gun was fired, it has to be angled upward, downward to cause that downward trajectory. We know that this shot goes all the way through to the bathroom in a downward trajectory because we saw evidence of that. The scene will reveal the evidence necessary for you to decipher what happened. Whoever was holding the firearm had to have been taller than 5 feet 5 inches tall. We know that there was no stippling found on the wounds of Jayla Bass, meaning that whoever fired the weapon pointing right at her had to be at least, from the testimony, at least 2 to 3 feet away from her. If you follow the trajectory of the bullet holes that you see here, take them out 2 to 3 feet, that takes you off the bed. At a height consistent with the defendant holding his hand above the rail and pointing it downward. We know also that the person standing on the outside of this bunk bed, at least 2 to 3 feet away from where the children were laying. We know the trajectory as well because of the impact blood stain pattern. Now, Anna Cox, when she testified, was very educational when she was describing to you what blood stain pattern analysis is. She explained that it's a discipline of forensic science focusing on identifying, documenting, and analyzing blood stains in order to interpret what caused the distribution. Basically, in a layman's term, she says, she looks at the blood stain and tries to decide how it got there. She went on to explain to us different kinds of blood stains and what they mean and how she interprets them. One of them was an impact blood stain, or an impact spattered pattern, which she said a natural object striking the liquid blood. She said she considered things such as physics, the natural laws of gravity, and introduction of a mechanism such as force. So if something were to hit an object bleeding, it would cause a certain pattern, a blood pattern stain. Directionality, flow pattern. She said in her expert opinion, based on the DNA evidence that was swabbed from this area, it showed that both JJ and Jayla's heads were in this corner of the bed at the time in which they were shot. That's an important piece of evidence because, remember, we end where it began. When defense mentioned in their opening statement to you that their client didn't pull the trigger. Well, members of the jury, it's one thing to make a statement like that and then move on. But it requires you to pull the thread, to follow the analysis, to let the scene reveal to you what happened. And you have to follow it until the end. The end is the DNA on the firearm. Now, recall this series of events. The children are shot. They're on the top bunk. When law enforcement arrives, the defendant is holding his son, who's profusely bleeding from a gunshot wound to the head. When he's asked, "Where's the firearm?" he explains to the deputies that it's on top of a dresser, and later explains that it's in the drawer in the master bedroom of the dresser. So let's keep pulling the thread, because what does that mean? It means that after he murdered his daughter Jayla, and after he shot his son in the temple, that he left them there, walked all the way past 2 bathrooms into the master bedroom, and he opened up that silver drawer. He put the gun and the magazine inside, and he closed that dresser drawer before doing anything else. That's significant. The gun was in a closed dresser drawer. If an accident happened in the room with his children, would not a reasonable parent render aid immediately?
Objection, Your Honor, improper argument.
Overruled.
It's not reasonable to believe that it was an accident. It's not reasonable to believe that after this firearm accidentally discharged 5 times, that someone would then walk past 2 bedrooms into a different room, open a drawer, place the firearm inside of that drawer, and close it before doing anything else. It is not reasonable to believe. We also know the defendant didn't call 911.
Objection, improper argument, Your Honor.
Sustained.
The phone records show that at 10:34, the defendant dialed out to a number belonging to his mother. Anna Cox was right. The scene reveals the evidence necessary for you to come to a conclusion as to what happened. The defendant loaded his firearm with a magazine. He slid it back to load it. He then stood on the outside of that gray bunk bed, put his arm up and over the railing, and fired at his children as they lay sleeping in the top bunk of the bed. The evidence reveals that he shot his daughter Jayla 3 times, and she died. The evidence reveals that he shot his son JJ in the temple, causing severe injuries that he still suffers from. The DNA puts the firearm in his hands. The trajectory puts the firearm in his hands. And members of the jury, the evidence, when put together, forms an arrow pointing at the guilt of only one person in this case. The defendant, Jermaine Bass, murdered his daughter, Jayla Bass, who was 5 years old. And he did it with intention, he did it with precision, and he did it with premeditation. The defendant tried to kill his son, JJ. And he did it with intention, he did it with precision, and he did it with premeditation. And the law and the evidence demand that you find him guilty.
Yep, take down the exhibit.
Oh, no, that's the right. I thought I mixed them up. I did not. We're missing.
She knows.
Be seated. Ms. Schlimmer?
Thank you, Judge. May it please the court,
Yes, ma'am.
counsels. I was going to start talking about everything Mr. Terry talked about in opening statement and what he did or didn't show. But I want to first go ahead and respond to Ms. Reeder if I can. First of all, she said, these are things we know. These are things we know are true. She said that Mr. Bass left the children home alone in their beds. So they're in their beds and he leaves. There's no evidence of that. You didn't hear any evidence that they were in their beds when he left. He followed Shirley Bass. We have an hour later with his car supposedly leaving, a Nissan Titan design, but he followed her. There's not one shred of evidence of that. To confront Shirley for going to a family dinner is why he supposedly stopped them along on the way onto 275 at the West Shore exit. You heard not one piece of evidence that he stopped the vehicle. And we're going to talk more about that later. But that it was to confront Shirley for going to the dinner? No, we didn't hear any evidence whatsoever about why or why not Mr. Bass did not go to the dinner. The children were laying down, we know that. Well, then why do we have bullet holes higher up? We don't know that. Miss Reeder actually said, quote, read between the lines. Do you remember when she just said that in her argument? Read between the lines. Let's forget about evidence. Let's forget about burden of proof. Let's throw it all out the window, folks. Just read between the lines and convict a person of murder. She went through this long, elongated theory, and I think it was done multiple times, that Mr. Bass got the gun. He put bullets in it. He put the magazine in. He racked it. He took it into the kid's room. What evidence did you hear about any of that? You heard not one piece of evidence of where that gun was prior to the shooting of the children. You heard nothing. We do not know. You don't read between the lines in a case such as this or in any case. There is absolutely no evidence that the state has presented where that gun was prior to the shooting, who loaded it, was the we know nothing. And they have to have evidence. Ms. Michelin told you that they didn't do a trigger pull. They could have done a trigger pull on that gun and given you a poundage of how much force. I think Ms. Spradley had asked her, it's about just 5 pounds. But what did she tell Ms. Spradley? The trigger pull on that gun is as easy as popping off a soda cap. Popping off a soda cap is enough force to pull the trigger on that gun. So the state wants you to believe that Mr. Bass did all these things. Well, because that's their theory, that's what they want you to believe. He got the gun, he racked it, he put the magazine in, he pulled the slide back, all of that. But you gotta look at the evidence, not their theory. Remember, the judge will tell you the evidence is where you look, the exhibits and the testimony. Not one piece of evidence about that. Ms. Reeder talked about the wallet being found next to ammo. I guess to presume that that's an important factor. Not any ammo that could have been used in this case for certain, because there's not one thing found in the master bedroom that had anything to do with a .380. Detective Hobelman and Corporal Gabeau both told you that. How do I know? How do I know that Mr. Bass's driver's license height is even correct? Not one shred of evidence presented as to that. They want you to read between the lines and assume. Whoever is holding the firearm had to be taller than 5'5". We know that, said Ms. Reeder. Where did you hear that evidence? What witness said that? Nobody did. Theory, not evidence. And again, going through how he then afterwards goes into the master bedroom, does everything, puts the gun up, and closes the drawer, she said. Right? Evidence. That drawer's open, so that's not true. This is the way HCSO found it. That drawer is open. So what Ms. Reeder said there is not supported by the evidence. There is not one shred of evidence to support their theory and everything Ms. Reeder had just said to you. You've got to look at the evidence. You've got to look for the evidence. So let me go back then. In opening statement, Mr. Terry told you the following. Mr. Bass doesn't call 911. You will find out who he calls. Well, Shirley calls 911, or Mr. Evans actually calls 911 and gives the phone to Shirley. Shirley's calling 911. Why is there a reason for the spouse to call 911? You heard evidence, not theory, but evidence, that DeQuan and then Shirley, the call is made at 22:33, the 911 call. Mr. Bass does not call his mother until after that. Evidence, that's what you heard. Mr. Bass isn't calling Domino's to order a pizza. He's not calling for takeout. While Miss Bass is on the phone with 911, that is when Mr. Bass calls his mom to tell her what happened to her grandchildren. So we know from the timing that that call to the mother is definitely after the 22:33 911. Look at the phone records. It is 22:34, right after. We also know that it's a very quick call. 5 seconds may not have even have been answered by his mom. All right, number 2. Mr. Terry says, Mr. Bass tells the police exactly where to find that gun. Presuming, I guess, he knows specifically because he's the one that pulled the trigger. Well, no, not quite. And Ms. Reeder even pointed this out in their argument, is he's telling them that it's on the dresser. It's not until later that he says, look in or on the dresser. Ms. Reeder even told you that. And we have no evidence of where that gun was prior to the shooting. None at all. Ms. Reeder made a comment about Mr. Bass making the statements to the deputies that first responded. The statements are made mere minutes after the shooting. Well, the 911 call is at 22:33. The statements, she said it herself in her closing, 22:46. That's 13 minutes. Marital discord. Mr. Terry said, oh, there's marital discord, and maybe that's why he did this tragic, horrible act. What evidence did you hear of marital discord? Absolutely none. Again, you have to look to the evidence, not their theory. Because they have the burden of proof to prove beyond and to the exclusion of a reasonable doubt. You did not hear about any marital discord from China Gadsden, nor did you hear about any marital discord from Ms. Romeo. Mr. Terry said, you will never know why. He's correct, absolutely, when he says they do not have to prove motive. You will never know why. Well, we don't. And the problem is, there are so many unanswered questions over this tragic, terrible event that took place on August 29th of 2022. Many unresolved questions, mistakes made in this case by many different people, too many unresolved or answered questions, reasonable doubt. Mr. Bass didn't go to Ruth Chris because he was supposed to stay home to take care of the children. Mr. Terry said that. Where'd you hear that? Did you hear that evidence? Stayed home because he had to take care of the children. No evidence. Nada. There was no evidence presented of why he did not go to Ruth Chris that evening. Something is not right in that house, okay? What evidence did you hear that there were any problems in the house? Nada. Mr. Terrigan, Mr. Bass was angry and aggressive on West Shore and 275 when he came upon Miss Bass and Miss Gadsden. Well, no, that's not what we heard. We specifically did not hear from China Gadsden say he was angry. You didn't hear that. Nada. She claims he comes upon them and all he says, were you drinking? You know, is that why she's driving? That's it. They're not arguing, they're not beefing, he's not yelling. Shirley wasn't fazed by it, China said. And that's it. And, folks, that's if you believe this story. Okay, we have China Gadsden, the one, she is related to Shirley. And one of the most critical things is, if this was a big deal, and this somehow is their great motive, theory, that's what they want you to believe to convict somebody of first-degree murder, why is it not talked about earlier? China Gadsden never says a word until over 14 months later that this allegedly took place. Corporal Gaveau even told you there would be times he would call China. She'd hang up on him. I don't want to talk to you. I'm not going to talk to you. All of the behavior of everybody in this case, Mr. Bass, Mrs. Bass, the witnesses, you can consider. And their behavior and everything that got done that evening. And China Gadsden never at any time said Shirley was upset. Now, I just want to make this comment. Do you honestly believe in Florida that they're sitting there, stopped in the middle of the road, and they're just sitting there, and Mr. Bass goes out and he says, were you drinking? Because is that why she's driving? That's it, right? That there's a ton of cars backed up, and not one person is honking. This is Florida. Not one person is honking or blaring, saying, you guys need to go. That's what China told you. Miss Bradley asked her, well, weren't the cars like honking if this story is true? Oh, no, it's fine. They were just waiting. Come on. It's just unbelievable. This was an act to kill, Mr. Terry said. Well, where's the evidence? Where is the evidence of premeditation, the intent to kill, reflection, enough time to reflect on that? Where is the evidence that the premeditation and intent to kill was in his mind before the act? We have no problems talked about, no issues, no evidence, none. No threats, nothing. Shirley was frantic on the 911 call, of course. She's frantic, she's upset. But you gotta look at her overall behavior in this case. You can look at all of that, and you should look at all of that. The 911 operator is constantly asking her, who did this? Who did this? Is the shooter still there? This is a mother. Supposedly, Mr. Bass has just shot and killed her daughter and shot her son. She refuses to answer that question. Never answers that question. At one point, Miss Bradley talked about this in her opening. She specifically says, no, I don't need police, I need an ambulance. And of course, you'll have the call to listen to. We also have absolutely no clue who she's yelling at on that call. We know for a fact from the call, she's definitely yelling at the 911 operator for not getting there fast enough to bring the ambulance. We know, and she says it, how upset she is with the operator. Look at when the call comes back. She even says, I got the same person. I got you again. So we know she's upset with the operator. And listen to that call. Did you catch the comment about what Shirley said? Her son was supposed to be sleeping But then he ran. What? Okay. Well, that just further shows me we do not know what happened in that house at the time of the shooting or what happened before. Listen to that call. You're going to hear her say that. And then he ran. Supposedly, as Miss Reeder says, the children are shot in their beds. That makes absolutely no sense. Now, we know from Mr. Evans, Daquan Evans, that there was about 5 to 10 minutes span of time. That's what he testified to. Evidence. 5 to 10 minutes from the time he heard the shots to Shirley coming to his door, because she doesn't know the address where she lives, she doesn't have her phone. 5 to 10 minutes between the shots and Shirley coming to his door. What is going on in that 5 to 10 minutes? Ask yourself that. What is going on with Shirley, Mr. Bass, in those 5 to 10 minutes? We also know there's 2 parts of the call. There was no evidence presented by the state to show the time difference. In other words, was there 5 minutes between the calls? Was it 5 seconds? We don't know, because they didn't present that. And we certainly know, continuing in that second call, Shirley is still not happy with that operator. Take that in consideration as well as the first deputies at the scene. They're all equipped with body cam. Rahman, Rainey, White, and Jones. The big picture is what you can look at. Deputy Jones, I asked her repeatedly, who shot her son? He's asking a mother whose son has been shot in the head. Who shot your son? Is the person with the gun in the area, please? Never. His testimony, evidence. Shirley never answered him, never answered his questions. Deputy White, evidence. The woman was yelling at the officers. We were just trying to help. Deputy White, Shirley was uncooperative in providing any answers. Evidence. Now the state, I anticipate Mr. Terry's going to get an opportunity to come up and talk to you when I'm done. Please keep in mind what he says and think what I might say in rebuttal to that, and keep in mind he has the burden of proof. But I anticipate, since this is my only time to talk to you, he's going to say, well, she was traumatized, right? She's traumatized. So you got to look at that whole big picture about her uncooperativeness, and we'll talk more about that. But it doesn't explain this case and not answering simple questions posed to her by a 911 operator or the deputies. Who shot your son? My husband. Never, nada, never says that. Deputy Jones, the lady wasn't very helpful. That's it. Not helpful at all. Now, Mr. Bass, another comment from opening statement by Mr. Terry. Mr. Bass never tells the police his daughter is upstairs. Not true. Evidence. You heard from Deputy White. Body cams, you got beeping going on, they're difficult to hear. Deputy White said that Mr. Bass did say something about a little girl, and he documented it in his report. It wasn't just off his body cam, he told you that. I heard that. What you kind of hear on the body cam is something like, anyone upstairs? No. Then you can hear something. Watch those body cams again. Something is said right after that. And I believe that Deputy Rainey's body cam may be one of the best to pick it all up. But listen for the word daughter. Then, is anyone else in the house? No. But I didn't make that up. Deputy White took that witness stand under oath and said he did say something about his little girl. But Mr. Bass is not allowed to be traumatized. Well, Shirley Bass is. You can't have your cake and eat it too. Now, Deputy Jones even told you, well, I didn't hear that. I didn't document it in my reports that he said no, but I was walking behind Deputy White. And I just walked quickly past Mr. Bass. And he specifically told you he might have heard something, Deputy White, that Deputy Jones did not. Evidence, that was his testimony, because Deputy Jones was behind Deputy White. Evidence, he told you that. So I ask that you watch those body cams again. I'm sure Mr. Terry will say the same thing. Now, let's continue on concerning Shirley Bass. Her daughter was killed in a tragic event. Her son was shot in the head. But she desires to be uncooperative with Detective Gabeau. He asked for her phone. Remember, her phone was in the crime scene. Some member of HCSO went into the crime scene, took her phone out, and gives it to her. So she has her phone back. Mr. Bass's phone, able to be downloaded, is on the couch. You can see it, right? He's asking, I want to download the phone. No. Never does she give her phone to him to do a simple download. And guess what, folks? You saw phone evidence, right? Now, I believe it was Corporal Gabeau said there wasn't anything on Mr. Bass's actual download, but that's why they look at it. That's why they do a cell write. Because it does reveal evidence, and it is important. She was hard to reach, he told you. This is a woman whose daughter was killed and son was shot in the head. Mary Lee House, you heard about Mary Lee House. It's kid-friendly. There's just the interviewer that works at Mary Lee House who's trained to speak to children in a kid-friendly environment. They have to do, and they want to do, an interview of JJ based on what happened, what he saw, what he did. On 9/7 of 2022 in the AM, Shirley absolutely refused to let her son be interviewed. Now, the state's going to say, oh, just Corporal Gabeau said he was just out of the hospital. Well, then say that. Can we wait a little bit? No. She lies to Corporal Gabeau, you heard that, and said, well, I got here earlier and I waited a long time. Remember he told you that? What else did he tell you? That's not true, because I was here early and she was not here. So we know that's false. And Corporal Gabeau, what other interesting thing did you hear about that first attempt to interview JJ? Oh, I never even saw the son. He doesn't know if she even brought him that day. So he says, okay, let's reset it for the afternoon. Same day, September 7th of 2022 for the PM. Now at this point, JJ's uncooperative. We didn't hear testimony that he was in pain or he was upset. Look what had just happened to his sister. We don't hear that. What do we hear? And I hate to even talk about JJ like this. I'm just going to tell you the evidence, please. Corporal Gabeau tells you the interview did not take place, that second attempt, because he was disrespectful, had bad behavior, and was actually physically attacking Shirley. Then we have another attempt. Well, let's try to do it on 9/12 of 22. It's now reset for the third time. That interview didn't take place. We know at that point, Detective Brunel and Detective Latou have to go get an investigative subpoena. Corporal Gabeau told you all about that. It isn't an invitation, Corporal told you. It was served on her on September 23rd of 2022. So finally, I think this is the fourth attempt at this point. You know, not Shirley, just give me some time. No. Excuses, excuses, excuses. Finally now, only over a threat of being arrested if she doesn't bring JJ in, does the interview take place. This behavior is not consistent with a woman whose husband just in cold blood, premeditated, shot his daughter, Shirley's daughter, 3 times and shot her son in the head. It just makes absolutely no sense. Corporal Gabeau told you she was uncooperative with the investigation. Some things she was cooperative with, he told you. He didn't quite tell you what those things were, but she was uncooperative. Just the same as you've heard from every single deputy that took that stand, the first responders. He also said, quote, Shirley was uncooperative with all attempts to have her son interviewed. What is going on here? What exactly happened in that home? What is going on? Do you really know, beyond and to the exclusion of all reasonable doubt, what happened in that apartment, that townhouse, for that gun to be shot and the children to be injured? Mr. Terry, in opening, Shirley was very frantic. He also seems to imply in his opening, but Mr. Bass wasn't, right? Shirley is frantic on the body cams, we see her. But nobody has met Shirley before and doesn't know how she acts. Nobody has met Mr. Bass before and see how he acts. Not Mr. Evans, not the deputies. We talked in voir dire, if you remember this. Do people act differently to trauma? You guys agreed, yes, you can. No two people are alike. You can be frantic, or you can be like a blank slate and in shock. It sounds like Mr. Bass and Shirley as well. So people react differently to traumatic events. And certainly being, quote, blank and quiet, the words of Mr. Evans to describe Shirley Bass describes Mr. Bass. In addition, you can consider what everyone else told you from the Sheriff's Department concerning Mr. Bass. Unlike Shirley Bass, he was cooperative with the investigation in all stages. Now, we also know that we hear Mr. Bass tells the deputies, come in, come in. You can literally see, watch the body cam, he's all sweaty. You can see the shine because he's sweat from trauma. Just help my child, please. I believe Ms. Reeder just said in her closing that he never asks for help or to help his children. Absolutely false. Just help my child, please, please get the paramedics. Again, evidence from the body cams. Mr. Terry, in his opening, Mr. Bass said it was an accident. This was no accident. Did y'all notice that when Mr. Bass is first asked by the deputies how this happened, what does he say? He says accidental discharge. That's what he says to me first. He doesn't say, I did it, I shot it. He says accidental discharge. It's a period of time. Deputy Rainey steps outside. He notifies that they have found Jayla and that the house is clear. Comes back in the house. They're frantically taking care of the children. Fire rescue is coming in. Later, when Deputy Rainey is asking more specific questions, then, and only then, does Mr. Bass says, it was me, I was cleaning the gun. Common sense dictates no one's going to be cleaning a gun in the kids' room. What is going on in that house? What happened in that house that tragic evening? We don't know. You didn't see any cleaning supplies out, did you? I submit to you, he was not in the kids' room cleaning the gun. He was protecting someone else. It just makes absolutely no sense. And evidence that you have is that we do know that there was a substantial period of time, 5 to 10 minutes between the shots and Shirley coming to ask to use Mr. Evans' phone. Why she's even doing that, I don't know, because her phone is in the townhouse where it's retrieved by one of the members and given back to her. And we know there's a gap in the calls. What did Mr. and Mrs. Bass discuss in that time period? Is Mr. Bass protecting someone? We don't know. Questions unanswered. That is when you have not proved your case beyond and to the exclusion of a reasonable doubt. So based on some of those things that we have just talked about, Do you believe that this case has been proved beyond and to the exclusion of all reasonable doubt? You have to look to the state for those answers. You have come away, or we submit you kind of have come away with more questions than anything else. Please keep in mind as well, we do not have to provide you, the law says, and try to explain who pulled that trigger, what happened, how the shooting took place. Remember, you need to look to the state for the evidence. We do not have to give you scenarios, explain what happened, discuss what happened. You have to say, did the state prove this beyond and to the exclusion of a reasonable doubt? So I want to talk about the law just a little bit, because we talked extensively in voir dire. Remember the presumption of innocence. You go back to that jury room. Keep in mind that it must be completely removed. We know we have a person and they're clothed in that presumption. That's our law in this country. It must be removed completely in order for you to consider a guilty verdict, in order to convict. Now, please don't be misled. There are no percentages in the jury instructions, but it's a way to kind of explain it to you. The presumption of innocence must be taken off of Mr. Bass 100%, right? Because that's the only way they can carry their burden and prove their case. If it's removed 50%, there's reasonable doubt. If it's removed 75%, there's reasonable doubt. If the state has only reviewed it,
Judge, I'm
removed
going to
it
object to this
95%.
line of argument.
Sustained. There's no specific percentage as relates to reasonable doubt. It's an abiding conviction of guilt.
And as I had told you, please don't be misled. Now, what is reasonable doubt? The judge gave the definition of it. She talked in voir dire about it and told you it's basically a doubt you can attach a reason to. It comes from the evidence, a conflict, or lack of evidence. Now, like Ms. Bradley told you in opening, this was tragic. Members of the jury had to see the photographs, listen to the evidence. Tragic. That was a tragedy, what happened that evening to those children. But you cannot let sympathy affect your verdict. I know it's hard. You cannot. The judge instructed you of that. You cannot let sympathy or bias affect your verdict. You must follow the law. And the question you need to answer is, has the state removed that presumption of innocence completely? And if they have not, the verdict has to be not guilty. That's our law. Ms. Reeder and Mr. Terry have done their jobs. And because they've done their jobs and presented evidence does not mean they are able, through the evidence, to remove that presumption. That's going to be that's up to you guys. As the judge told you in the jury instructions, I believe you have the copies, you get to go back there, the presumption of innocence must be overcome by the evidence beyond and to the exclusion of a reasonable doubt. And also remember, the abiding conviction of guilt and conviction of guilt. Judge gave you the instruction, we talked about it in voir dire, you have the instruction. That part of the instruction starts off talking what reasonable doubt, which is a concept sometimes hard to define, is what we talked in voir dire about. It's not a possible or speculative doubt. She told you that. However, if after carefully, or on the other hand, I believe it says, on the other hand, after carefully considering and weighing the evidence, there is not an abiding conviction of guilt, or if you have a conviction of guilt, but it is not stable, it wavers and vacillates. That means, and shows you the charge has not been proven beyond and to the exclusion of all reasonable doubt, and the law requires, it's tough in a case like this, but the law requires a not guilty verdict. That was what we were talking about. Mr. Terry, I stole from him in voir dire when he used the waver and vacillating to talk about premeditation. Same thing. You go into your closet that morning and you're trying to decide what to wear, and you can't quite decide. It's waver and vacillating, going back and forth. And if you can even have a conviction of guilt. No abiding conviction of guilt or conviction of guilt, but not waivers or gaslights. It has to be by law, not guilty. So if you go back in the jury room and you're thinking to yourself, well, he's possibly guilty, he may be guilty, he could very well be guilty, he's probably guilty, then you're having a reasonable doubt. And please keep in mind that we do not have to have proved Mr. Bass's innocence, rebutted anything that was said. I think we showed you quite a bit, and a lot of the problems and errors in this case. But at this point now, we're at Wednesday, there's just too many questions in this case to overcome that presumption of innocence. And those questions have not been answered. You cannot look at Ms. Reeder or Mr. Terry's theory. Evidence, evidence, evidence. As I said in jury selection, what does not guilty mean in our country? Well, that's exactly what it means. Not guilty means the state has not proved their case beyond to the exclusion of a reasonable doubt. So with our laws, do you have to sit there and go, I'm totally convinced he didn't pull the trigger? That's when I say not guilty. No. Our law says if the state has not proven their case beyond to the exclusion of a reasonable doubt and remove that presumption of innocence through evidence, not theory, then you have to, by law, return the not guilty verdict. The state has to prove who did it and has to prove Mr. Bass acted with premeditation or felony murder. You have the instructions with you. So I want to just talk a little bit then about the crime scene, the autopsy, and they all present holes in the state's case. Let me start off with Dr. Riley. Mr. Terry said to Dr. Riley in his direct examination, and Dr. Riley agreed, were you there the entire time for the autopsy? Yes, I was there. I wrote the quote. I was there with Dr. McGowan the entire time. Well, no, that's false. We know that's not true. We presented that to you. I said, whoa, hold up. Again, we didn't have to do this. I go up and I'm like, whoa, wait a minute. You weren't, were you? You were in and out. You had other autopsies going on while this autopsy was taking place. That is correct. And I had other things to do as well. But yet he told you, oh yeah, I was there with him the entire time on direct. Dr. McGowan did the autopsy. Dr. McGowan did the report. Then we have the interesting issue of Dr. Riley, and I'll explain in a minute why all this is important, and then we'll talk about the other mistakes in this case. Dr. Riley testified under oath in his deposition that gunshot wounds A and B on Ms. Shirley Bass, were slightly downward. He took an oath, he testified they were slightly downward. That's what's written in an official document, the official autopsy report. So it's in the autopsy report, testifies under oath. That's wrong. What else could wrong? For this autopsy, he was doing other things, doing other autopsies. It's important. So it's wrong at least twice. You heard that. And it's funny because my last thing to him was, but didn't I even ask you in your deposition when you were under oath, did you find any errors in that report? And you said no, and I think his exact words were, this is something I would say. Okay. So Mr. Terry gets back up on redirect, but does that have anything to do with the cause and manner of death? And Dr. Riley says, no, I have not changed my cause and manner of death. From the autopsy he did not conduct. Why does it matter? What the autopsy showed matters. What the autopsy didn't show matters. Stippling matters. Direction matters. Where a person is shooting a gun that he can testify or not testify to matters. His findings matter. What else is wrong? What else is incomplete? And this is the type of evidence that Mr. Terry and Ms. Reeder would claim they have carried their burden of proof with. Dr. Riley, honest with you on these points. I cannot tell you who pulled the trigger. I cannot even tell you where the shooter was. Remember, Miss Reader? Oh, the shooter was standing right next to the bed. It's Mr. Bass, and he puts his arm over and reaches and shoots. You heard no evidence of that. You heard to the contrary. Dr. Riley says, I cannot tell you where the shooter was. Who else said that? Anna Cox. I can't tell you where the shooter was. I can't tell you any of that. So what is all this? Theory, not evidence. Now, this is very important when it comes to the stippling, because they're talking about there's no stippling on Jayla's wounds. Dr. Riley said there's no evidence based on what he sees for close range firing. And he told you that is the only thing that indeterminate range means. What else did he tell you, though? There are many variables and numerous factors that can affect the leaving of stippling. Number one, the type of firearm itself, which, by the way, he wasn't even aware of what type of firearm. Number two, the type of the firearm. So the firearm itself and how it works, and then the type, 38, 9, 57. And it depends on how much gunpowder is in the cartridge of the ammo. So these are all factors that he is telling you, evidence affects whether you can see stippling or not. No further testing was done by HCSO to fire the gun and see that gun with that specific ammo where you see stippling or if you see stippling. Now, State wants to also talk about distance. Ms. Reader, I think, said something about Mr. Bass puts the gun right up to them or to their heads, something like that. I specifically asked him, are you able to give us an opinion on how far, in this case, the end of the muzzle, so where obviously you guys know about firearms, where it ejects, that's your distance. In this case, I cannot tell you that. I have no opinion. Remember that? Evidence. When he's talking about, well, generally you'll see stippling under 3 feet or under 2 feet. Generally. Typically. But I need the firearm. I need the ammo. And he, of course he doesn't do that kind of stuff. HCSO would be responsible for actually testing that firearm. So, and of course we have no evidence concerning little JJ in that field. So, keep all of that with a grain of salt and remember what Dr. Riley really said. Shannon Bader and Clay Hoagland, what other errors did we have? Why is it important? Guarantee you Mr. Terry's going to get up here and anything I said about what about this, what about this, what about this, you have questions not answered. He's going to say, that doesn't matter. I have to prove that Jayla is dead, and we've agreed to that. Clearly it was Shirley Bass. He's got to prove the elements of the crime. But you look at the whole big picture. How was the evidence collected from the scene? They relied very heavily on Ms. Cox's opinion. I'll get to her in just a minute. But here's something pretty critical. Shannon Bader made a mistake. She puts in her report, she puts on property receipts, and she says in her deposition under oath that projectile was taken from the bottom bunk mattress. So what would that make that look like then, right? It makes it almost look like she's telling you, or the evidence at the time, is that one of the shots or two of the shots, what have you, are on the bottom bunk as well. So that's her mistake and what her mistake led to. That's important. That's important. Because we know that's not the case. But yet when you look at this, wait, what is their scene saying? I think Ms. Reader said it 5 or 6 times. What is the scene telling you? What is the scene telling you? The Sheriff's Department collects a metal clip, evidence marker 1, for like gauze when a person has a wrapped up arm or something like that, a little metal clip. And they collect or they document it. I wasn't sure if they collected it or just documented a piece of gauze on the top of the staircase. That was important enough to do. Well, what wasn't important enough? Let's go over that. Gunshot residue testing. You have the kits, you can do it, and then send it off for testing, which they told you they can do, but they did not do. Now, I believe Miss Reader or Mr. Terry was talking to, I think, Corporal Gabot today. And he says, well, you wouldn't bother to do that on Mr. Bass because he admitted he shot the firearm. And he said, well, yeah, that's why I didn't bother with him. What about everybody else? Everybody else was at the scene. The medical examiner's office had some sort of question concerning, you heard about this, whether they should swab poor little Jayla's hands, because her hands are bagged to protect it. What did Clay Holbleman say when he spoke to somebody at the medical examiner? Nah, we don't need any special processing. We're not worried about that. So there's a lot more to that picture. There's only one swab done on that entire top mattress, and that's the swab over towards the pillow that came back as little JJ. One swab is done on the entire, and I'm only speaking of top of the mattress, to determine or try to determine possible positions of the children. I asked Detective Holbleman, well, why wouldn't you do, look at all that blood. Why wouldn't you do some other swabs? I'm not talking about the frame, I'm not talking about the wall. I'm not talking about the staircase, where we know we have little JJ's blood. Why would you not send out some more swabs? You have blood on the east end, in the middle, and on the west end. We can tell from the evidence Jayla is clearly somewhere near the pillow, yes. But I asked him, why did you only send swabs from the magazine, the trigger grip, the slide, and the one swab that Anna Cox wanted done on the comforter? Well, it would take too long. It takes a good 12 months to process things. I wouldn't have had it ready for trial. So that's why I didn't bother. That was his answer. I don't make this stuff up. That was his answer. What did I talk with Ms. Weinstein? I hope it is. I'm not mispronouncing that. We talked about her reports, right? 3 months. And that's 3 months from the evidence coming into FDLE, being in their evidence vault, eventually making its way to her area, being processed, filing a report, and authoring a written report. 3 months on pretty much everything she did. There was plenty of time to process this scene better, so maybe you would have your questions answered. This was mid-2022. It is 2.5 years later. The only swabs that are done on the frame, not where B is, where they saw a substance. We saw red substance on the frame all down on the east end. And I'll get to the comforter in Miss Cox in a minute. All swabbing over there. I'm not talking about swabbing on the west end, where clearly we have the coagulation and where little Jayla is shot. We have it on the west end. We have it in the middle. We have it on the east end. We have it on the walls and the frame. Look at that east side. Not one swab done. That would help us with movement. That would help us know. Now, Anna Cox, who does 70% of her work for prosecutor's office and police agency, she wants you to believe that every bit of blood on that comforter, because we only have the O tested, and then we have the impact spatter up on top, the one area of impact spatter, which has Jayla's DNA and a limited inclusion for little JJ. You have the DNA results. But she's telling you that every single bit of blood in the middle of that mattress and going all the way to the east side, that's all from the comforter. You saw multiple pictures of that comforter. It's in different spots, even in the picture. Walls, frame, and mattress. We know it's moved by first responders. If you see in the body cam, it's kind of next to her legs. There's a picture with the comforter. You'll have the pictures back there, laying in the middle of the bed. Remember that? And I almost said, well, there's a U-shaped here. It was kind of spread out. And there's a whole bunch of blood right here that's not even touching this comforter. Oh, look at the whole sequence of photos, Ms. Cox says. You have the photos. Then we see a photograph of it way over on the east wall. That's the preservation of their scene. Multiple locations of one piece of evidence. And guess what? Detective Hobelman had absolutely no idea that first responders had moved that comforter, moving evidence in the crime scene, until I told him. I told him in deposition. It's in the body cams. He didn't know that. And he's the scene detective. We had to tell the crime scene detective in a homicide case where children are shot these things. That's a problem. That's a problem. We know that they had the issue with the label of the B. They thought B went through the wall and was B1 and B2. That's a simple mistake. They moved the bunk bed away, and they could tell that B is not related to B1 and B2. Right? Yet Anna Cox sounded very sure of herself. In fact, I think Miss Reeder used the term, she taught you. If you'll happen to notice as well, she appeared to be the only witness in this case who continued talking and after the question had been answered. Everybody else answered the question as they should. But here's what's critical. Jayla's head and Jermaine's head and possibly his hand was at the northwest corner. Why? Why are you so convinced of that? Because of that one area, P, the impact spatter. That's why she's convinced. He said, well, all gunshot wounds aren't going to leave impact spatter. Oh, yes, they will. Generally, in my, you're going to leave your common sense at the door. You don't have to leave it at the door. She was even aware that P, the impact spatter spot, was a limited, little Jermaine was included in a limited capacity. And you have the stipulation on that. So then I said to her, well, look, all right, she's processing a scene which had been not done 100% correctly by HCSO. Some mistakes are made. You can't give us the exact position of Jayla and little JJ's head, correct? Oh, yes, I can. It was in the northwest corner. I'm like, okay. She said it again and again. I said, hold up. That's not what you told me in deposition under oath just December of last year. That's not what she said. I had to show her her own words. She said, proximity of the northwest corner, I cannot give you the exact position. Just somewhere in the proximity of the northwest corner. That's what she said in December, under oath. She comes in, teaches you, shows you her PowerPoint. Oh no, yeah, no, their heads are definitely there. You can consider that. And of course, none of this that we're even talking about so far about the crime scene and the autopsy is telling you to pull the trigger. So you can consider all of that. Talking about Ms. Cox, don't you think if the sheriff's department had seen biological material, that somebody would have mentioned it, somebody would have put it in a report, somebody would have had that tested? She looks at some pictures, photos only, and says, oh, that's biological material there. Well, do we know? Was there DNA done? Do we have any idea? Just a picture. Well, no, that's what it looks like to me in my experience. Okay. It was also interesting because she said something about drips of blood by the couch. I guess away from the couch, because we know Mr. Bass is sitting there cradling his son. The officers all told you there's blood coming down. She said something about some drops. That's not documented by Bader or Holberman. The green scale marker on the ground there shows what you decide. It looks like a little footprint. We know that's the area in which Mr. Bass brings his son down and sits down on the couch. You didn't hear about little droplets on the floor from the sheriff's department. And you know what? I guess even if they were there, like she said, that's understandable through the evidence. We know for a fact Mr. Bass brought his child down. Just like the blood that's down the staircase and all that, all understandable, all explainable, and she told you that. Why wasn't anything done at all with the swabs taken for the gunshot residue? The comforter, wherever it is, you know, it's more towards the left, could have been right under where that gun was, and where the gun's being fired. In fact, I think Ms. Reeder says kind of that it's lifting over, going right on top of it, to show us positions. But why wasn't anything done then, at all? Well, we don't know. They took swabs for gunshot residue, they did infrared light, did nothing with it at all. I believe I asked, it was Detective Holberman or Corporal Gabot, further testing could have been done. FTLE results. Item 7, the magazine, and item 8, the grip and the trigger, have the son's DNA. Now, I've been working with Mr. Terry a long time, and I can kind of predict what he's going to say. Keep in mind again what I would say when he gets up here. But I presume he's going to claim, oh, it's just some sort of transfer. The fact that DNA, the biological profile of that little boy, is on the actual grip, trigger, and magazine of that gun. What happened in that house? Transfer in all those spots, Mr. Terry? All of them are just transfer? Well, with those statistics, no. I even asked Ms. Weinstein what the actual statistic was for little JJ's DNA on the grip trigger and the magazine, because she capped it at the 700 billion, which understandable, it's greater than 700 billion. They don't bother reporting in their report, they put it in their notes, what the actual statistic is. So I asked her, what is the actual statistic for the trigger for the son's DNA? Way more than 700 billion, 640 quintillion. I had to ask her how many zeros that was. I can't remember if she said 20 or 30. You guys rely on your own memory. With those statistics, we ain't looking at transfer, folks. What happened that night in that house? The magazine, 310 trillion. Not with those statistics. Ms. Weinstein did tell you that they usually typically say, I expect a donor to be there. She flat out told you I would expect Mr. Bass's DNA to be on that gun. He would be an expected profile, and he was. It's his gun. So the state wants to focus you on that. Well, his DNA's on the gun, that means he committed this crime. Absolutely not. What did FTLE also say about the magazine? Mr. Terry, when he was questioning Ms. Weinstein, said, so Shirley's DNA is not even on the magazine, right? I objected. On cross, I asked, no, I can't include or exclude her. I'm not saying her DNA wasn't there. On the magazine, Shirley cannot be included as being a donor or excluded as being a source of the DNA on the magazine. And the FTLE analysts cannot tell you anyone did not touch that gun that evening. But what else is important that she told you? There are actually ways to do statistics, because we heard the statistics, 1 in 600 trillion, 1 in 700 billion, for it to be some other unrelated person. I said, wait a minute. We keep saying unrelated when we know this is a biological family. Are there statistics that can be done when it involves related persons? Oh, absolutely. Yeah, there can be a way to do the statistics when we have related people involved. But we didn't do it in this case. FDLE's not doing that. Everyone's related. Why didn't they do it? We don't know what the statistics may have been. On the magazine, we had little Jayla included when running the program in StarMix. She uses StarMix, she puts the profile in, it helps her sort out the contributors. She ran it as a 2-person mixture. And Jayla at that point was included, 25,000. That's a much lower statistic. But she told you, and I had to ask her this, wait a minute, couldn't you have chosen to run item 7, the profile in the magazine, as a 3-person mixture in StarMixed? And I showed her, we talked about her correspondence. She questioned whether she should have done that. She ran it, she chose to run it in the StarMix program as a 2-person mixture. That is her subjective doing. I'm running it as a 2-person mixture, and now in the end, we only have JJ and Mr. Bass. So we talked about her correspondence with her supervisor, and she said, yeah, we did discuss this, and I made the decision I'm going to keep it as a 2-person mixture. Ms. Michelin was our last witness. The gun that ejected the casings was that gun located in the master bedroom. And according to Ms. Michelin, to pull the trigger on that gun is like opening a soda cap with a little metal clip. Now, Ms. Reeder, in her closing, is like, well, you have to do this, and you have to do this, and you have to load the gun, and you have to rack the slide, and you have to do all this. There's no way a child could have done all that. I'm presuming that's what they're saying. All 3 safety mechanisms on that gun are joint. That's what you heard. So when you pull that trigger, the 3 safety mechanisms on that gun in different areas disengage. The only thing you have to do is you pull that little thing that's in front of the trigger, right by each other, and you pull it. You don't have to keep racking the slide. You just pull it back, like popping a can of soda. And remember, we don't have to show you scenarios. We don't have to say we believe this is what happened or we believe this isn't what happened. You have to look to the state and say, did you prove that Mr. Bass pulled that trigger and did it with premeditation or felony murder? Because we could probably sit here all day and talk about scenarios. We're not going to do that. It is very strange what's in that kid's room. A baby little bassinet right in front of the bunk bed with, I guess she called it a clip to the magazine, is in that baby bassinet. What was going on in that room? No processing was done on it at all to see whose DNA, whose fingerprints might have left that right there. There's a purse in the kid's closet. I didn't make up the word purse. It is documented as a purse. A purse is in the kid's closet, a magazine, a holster, and .380 ammo. The same type of, I believe with the shots, there's like Hornady and Norma. The same type of ammo. There's a full box in there that could have been used in that gun. The purse is not collected. Well, I find this little clip being important, so let's make sure, we take care of that, or we do this with gauze, but let's not collect a purse, test it for DNA, ask people about whose purse it is, test it for prints to determine whose purse that is, and how in the world did it get in those poor child's closet? We don't know. And it's tragic. We don't know. The witness, I can't remember who I was talking to about it, it must have been Bader or Holberman. Yes, it was extremely odd to see this. So we have the sheriff's department documenting tons of stuff in the master bedroom, right? The gun, absolutely, the wallet, yes. But they're collecting all sorts of stuff out of that master bedroom, right? None of it had anything to do with this case. So that's important enough to do for them. I asked Corporal straight out, can you shoot 9mm, because that's what most of it was, 9mm, and then there were some bigger ones, in a .380? No, you cannot. Had absolutely nothing to do with this, but let's focus on that. Let's not focus on why in the world those items were in the children's room and why was the purse in the closet, or it's even a little tough to see when you look at the picture. And you have the pictures, and I had to ask, I believe it was Detective Holberman about that. The only .380 items, which is what goes in this gun, were in that purse in the kids' room. That ammo box in the purse, the holster, the clip, did you swab it? Did you print it? Why is it in the kids' room? Who does it belong to see who touched those items? No, didn't do that. We were more concerned about all this non-related stuff in the master bedroom. Jennifer Michelon told you that they could have done a trigger pull to give you the exact trigger pull for that firearm. Because all firearms are specific and different, and you gotta look at that firearm. Just like Dr. Riley told you, everything with stippling depends on all these variables. We do not have any evidence of that firearm, with that specific ammo being tested to see any stippling pattern. Nothing, we have no evidence to know. As she told you, I think she was honest with you in all her testimony. We could have done it, it wasn't done. She was the one that talked to you about how all the three safety mechanisms disengage, and then you have the little safety thing in front, it's like right in front of the trigger, all you gotta do is pull the trigger. There's no testimony that you heard, or any evidence you heard, about whether that gun was loaded or not, and whether there was one in the chamber. So if you're sitting here, like Ms. Reeder says, you have to take it out, you gotta put the magazine in, you gotta rack the chamber, get it loaded. You heard no evidence of any of that. We don't know where that gun came from, how it got into the kids' room, who shot it, who is Mr. Bass protecting. We don't have any evidence. None. None. But we can't sit back there and assume, oh, well, the children wouldn't have been able to do that because you gotta do this and you gotta do this. No. The lead detective in this case did not even know there was a box of .380 ammo in that kid's room. He found out during trial. Somebody told him, and that's fine. That's no problem. Somebody told him that. He didn't even know. He had no idea. He also testified, Corporal Gaveau, under oath in his search warrant, under oath in his depot, and made another mistake concerning the timing on the video. And he talked to you about that. And he admitted all that he had made a mistake, and his testimony under oath was not accurate. But Ms. Michelon told you it is like opening a can of soda. An adult can fire that firearm, a child can fire that firearm. And it's so funny, Ms. Reeder made a big deal in her closing about how Jennifer Michelon used both hands to hold that gun. She's a firearms expert. She's a grown adult woman. She has to be safe too when she's at the sheriff's department. That's not what we're talking about here. Of course she's gonna be safe and hold it with two. She didn't tell you, oh, I had to because of the way it was recoiling. Nope, none of that. Her testimony was what you heard, a can of soda.
These aren't mere possibilities. This isn't speculation. This is their evidence. This is their evidence that they want you to remove the presumption of innocence with. And they have not. Do you know what happened that evening? A lot of details we don't know. Many details we don't know. So, when the state has not, through no fault of Ms. Reeder and Mr. Cherry, that is the evidence, have not proven this case beyond and to the exclusion of reasonable doubt, I know it's hard. This was tragic, but the law requires a not guilty verdict, and that's what not guilty means. The state just hasn't proven to me beyond and to the exclusion of a reasonable doubt. There's too many questions and too many things we clearly do not know. So when the state has not proven their case beyond and to the exclusion of a reasonable doubt, you mark not guilty. Remember, that's what not guilty means. You don't have to be sitting here going, oh no, I'm positive he didn't do it, and that's what not guilty means. No, the state has not proven their case. Not guilty, not guilty, not guilty. Trial's almost over. Mr. Cherry's going to get an opportunity to come back and talk to you. Please give him the attention you've given me as well. Remember what he says and what I might say in rebuttal to that. But you got to ask yourself, do they prove to you that you know what happened in that house that tragic evening? And I would submit they clearly haven't. And on behalf of Ms. Bradley, and most importantly, Mr. Jermaine Bass, we want to thank you for being with us last Friday and all of this week. Thank you, Judge.
Thank you. Mr. Terry?
Yes, Your Honor. You know, it's interesting to sit there and listen to all that and realize she's got Schlemmer's doing her job. She's trying to find anything she can pick apart in the state's case, of course. She went through each witness and tried to find anything that they did wrong, any little tiny mistake. She spent a lot of time talking about Shirley Bass. And she ignored the strongest and the most important piece of evidence in this entire case. The words of her own client. The words of her own client, the first words that came out of his mouth when those deputies come in there to this horrific scene. She completely ignored that, ladies and gentlemen. She completely did. And in fact, I guess because she's ignoring it so hard, she didn't even get right what he said. He never said he was cleaning the gun. He said he was removing the magazine. That's how much she's ignored it, is that she didn't even get the words he said right. Listen to the tape. Listen to what he says. I was trying to take out the magazine and it went off. I wrote down the quote exactly. I never said anything about cleaning a gun. But she's not listening to those words because she doesn't want you to listen to those words.
Objection, Your Honor, improper argument.
Sustained.
Those words are the strongest and most compelling piece of evidence in this entire case. She wants to tell you, well, that doesn't tell you who shot that gun. You know who tells you who shot that gun? He tells you who shot that gun. Jermaine Bass tells you who shot that gun. He said, I did it. And those deputies and those detectives began an investigation believing that man said it was an accident. So they want to look and see what's going on. And then it comes to light, this couldn't possibly be an accident with 5 shots. But he admitted it was him. And one of the last things Ms. Schlemmer said, something to the effect of, who is he protecting? Well, where's there any evidence he's protecting anybody? Oh, I can tell you who he's protecting. He's protecting himself. Those words that lie was protecting himself. He's caught. Hand in the cookie jar. Children shot. He's in the house. Murder weapons in his drawer. He's holding the baby. What does he say? It was an accident. That's the first lie he could come up with, right? You couldn't blame Shirley. We don't even know Shirley was outside. He said Shirley was in her room. Shirley wasn't in that room, for sure. And why would he protect Shirley? Why would he protect Shirley Bass if she shot her children? He wouldn't do that. You know, earlier in the night, he was over there confronting her about whether she'd been drinking. Did you protect her? That common sense says to you, ladies and gentlemen, that is not going to happen. No. He came up, he knew he was caught, he came up with the first lie he could think of. It was an accidental discharge. And they're like, wow, for both of them? Yeah. Yeah. I was taking out my magazine and it went off. But she wants you to ignore that. She barely even talked about it.
Objection, Your Honor. Improper argument and shifting the burden.
Improper argument sustained.
That is the strongest piece of evidence in this case. You can rely on that evidence and that evidence alone. That's an admission, ladies and gentlemen. He admitted to those deputies that he fired that weapon. Came up with a ridiculous excuse, but he admitted it. But he admitted it, leaving just enough truthful nuggets in it because he couldn't quite figure out the right way to lie. So listen what he says. Accidental discharge. Okay, that's the first thing he says. I was trying to take out the magazine and it went off, right? They was both in bed. He said that. They was both in bed. No one told him where they were or what was going on or where they had been shot. That's actually true. They were both in bed. How did he know that? How did he know they were both in bed? Because he's the one who pulled the trigger. They was both in bed. Physical evidence shows they were both shot in that bed. I was in their room. Now he even puts the room where they were shot. He's got the bed, the room. That's all true. So he's mixed in his lie with a little truth. I was in their room. They was both in bed. Where was Shirley? She was in her room. Again, those are his words, not my words. Not words by the Corporal Gabot. Not words from Anna Cox. Not words from Jennifer Michaelon. Not words from any of those people. Those are the words of the defendant, the man right there. So every time Ms. Schlemmer says, well, that doesn't tell you who shot the gun. Well, I'll tell you who told you who shot the gun. He did. So Ms. Schlemmer said, he said clean the gun. That's not true. Another thing, and again, you need to rely on your own memory of the evidence. You need to rely on the evidence that you take back there with you. But she pulled that picture out to show the drawer open and the gun being. Watch the video camera, the body-worn camera of Nathaniel Jones when he goes in to clear that room. That drawer where that gun is found is almost completely closed. It may be open about this much. And it's clear that they opened it more to put the markers on there. So yes, in fact, the defendant did take that gun after his two children were shot in the head, and rather than lend aid or render aid to them, he took that gun and he walked through that house while his children were bleeding out in their beds, took the time to do that, remove the magazine. Oh, again, a little nugget of truth thrown in there with that lie. I was taking out the magazine. Yeah, he did take out the magazine. Why, when your children have just been shot in the head, are you taking the time to walk down the hallway, go into your bedroom, pull out the magazine, place the gun down in there with the magazine, and close the drawer? Does that make any sense to you, ladies and gentlemen? So that was the way he did that lied, but producing enough nuggets of truth that his statements actually had some truth in them. And only the only person, the shooter, would know what those statements were. Where they were shot is huge. We only know that from Anna Cox because Anna Cox, who's a bloodstain expert who you heard from, was able to tell you that based on the bloodstain pattern, there was only one place these two children were shot, and that was in that bed, in that little corner up there. They were both shot in the head up in that northwest corner of the bed. And he knew that. They was in bed. He knew that scene. He knew where they were. I mean, that's as close to a confession as you're going to get, ladies and gentlemen. He's actually giving you details about the crime, the location, specific enough to where they were in the bed. The shooter would know that. The person who pulled the trigger would know that. That is the strongest and most compelling evidence in this case. And to ignore that, because the medical examiner wrote upward trajectory instead of downward trajectory, or the vice versa, would be an injustice. Don't lose sight of the forest through the trees. Don't ignore the strongest and most compelling evidence of this case, because the crime scene investigator wrote bottom bunk instead of top bunk. She made a mistake. So not only do his words follow along with the evidence perfectly, other than the accident, that's the part he didn't want to admit. He didn't want to admit his intent. That was an accident, I'm
Object,
sorry.
Your Honor, comment on silence.
Overruled.
So instead of saying his intent, which was to kill those kids, it came out as, oh, it's an accident. But on top of that, the physical evidence also corresponds with that. The location, just where he said they were. Where they were shot, just where he said they were. His DNA is on the gun. He knew where that gun was. They'd be like, where's the gun? Where's the gun? It's on the dresser. Well, it's in the dresser. He knew. How did he know? Because he put it in there. Who does that? A man with a guilty conscience. A man who's trying to hide away the murder weapon. That's who does that. If this had been an accident, if someone else had done it, do you think he would take the time or bother to go and put the gun away? No, of course not. And it's no coincidence that gun was next to his wallet, because that's his gun. And you stuck it down in there. The shots were from off the bed. That's clear. If the shots to Jayla were from a person on the bed, meaning JJ, there would have been stippling, ladies and gentlemen. There's no way that he would not have been shot within 12 inches, she would not have been shot within 12 inches. And there would have been some evidence of a close range fire if JJ had fired that gun. There would have been evidence of a close range fire. That gun was fired from off the bed, at least 2 feet away. Who could have done that? Not JJ. Oh, I know who could have done it, the man who admitted that he did it. Ms. Schlemmer says, you know, she knows me, she goes, I'm gonna talk about transfer. Of course I'm gonna talk about transfer DNA. And yes, that is a very heavy statistic, so I have no doubt that JJ touched that gun, or that some fluids from JJ in some manner or another transferred from the hands of that man onto that trigger and grip. And remember, when she says trigger grip, she swabs the entire grip where you hold the gun as well as the trigger. So it could have come from the trigger, or the grip, I mean, it could have come from the trigger, or trigger could come from anywhere. But yes, that was transfer DNA. Now, possibly, and as we know, one of these shots goes awry. 5 shots were fired, 4 hit their target, 1 went awry. It went into the wall and into the bathroom. How could that maybe have happened? Maybe JJ, in an attempt to save his life, grabs the gun and pushes it away from his head, or from them. And the gun goes up and shoots away from him. Maybe JJ did grab that gun. Maybe it was transferred DNA. But there's no evidence that JJ would have shot this gun. He's an 8-year-old boy. No evidence he had any animosity with his sister, any issues with his sister. Those shots were targeted. But also remember, he shot himself. Are we to suggest that he shot his sister 3 times, then shot into the wall, and then shot himself in the head? Oh, and hit his hand at the same time? He didn't shoot that gun. That's silly. It's silly to believe that he would shoot his sister and shoot himself. And that just makes no sense, ladies and gentlemen. No sense. So yes, this DNA was on there, but it's easily explained. You know whose DNA is not on there? The person Ms. Schlemmer talked about the most in the first half of her closing, Shirley Bass. She is excluded from the grip and trigger. Excluded. She did not hold that gun that night. If she had held that gun and fired those shots, you better believe some of her DNA would be on that gun. She did not have that gun. There's zero physical evidence whatsoever that suggests Shirley Bass did this. You know, and I know that you all may be sitting here wondering, we didn't get to hear from Shirley. I wonder what she said. Well, I'm going to tell you something right now. You did hear from Shirley. All of you did. You heard from her in that 911 call. And I urge you very hard to listen to that call. Listen to it, compare it with the video we have of her outside DeQuan Evans' apartment. Listen to how her voice changes, timeline and everything, because I'm going to suggest to you what happens. And you watch this and you will see that this is in fact what happens. And listen to the audio carefully and you will hear this. First of all, notice that when she is outside, the very first time she's outside, and you need to watch the video very closely, and it's hard to see sometimes, but if you watch it enough times, you will know where the door is to the Bass household. You will see her come out, and she comes out at 20:21:15, which is at 10:21. So she comes out a while before she ends up at DeQuan Evans' house. And watch her out there. You'll see her in the parking lot, and she's kind of walking like this, and then she'll walk, and then she kind of walks another way, and then you'll see her walking this way before she ever comes to the area where DeQuan Evans is. She's out of that house for a while. So what does she say when she's on that phone call? You hear her, she's frantic, she's terrified. She can't believe what's going on. She knows there were gunshots in her house. She says, someone shot my whole family. She's petrified. She doesn't know what's going on. She knows there were gunshots. And then she says, I don't know what happened in this house. She doesn't know. She didn't see it. She tells you right there, I don't know what happened in this house. She knows there were gunshots in her house, that she's scared for the safety of her family, but she says, I don't know what happened in this house, but she is scared. You can hear that in her voice. but she's not super confrontational, right? You can just hear she's like scared, and she's not making a lot of sense when she talks. But then watch on the video. She has that phone for about 2 minutes and 20 seconds or so, 2 minutes, 40 seconds. And you'll see she starts walking back into the parking lot and she heads back to the house. And look at the house, you'll see the door open. And that's when she first screams in really loud, clearly not at the 911 operator, as they would have you believe. She's clearly speaking to someone out there. And she says, "What the fuck is wrong with you? What the fuck is wrong with you?" You know who she's talking to? She's talking to that man right there. What the fuck is wrong with you? Because she knows he did something. She knows he had that gun and she knows he did something. But she doesn't seem to really know what yet at this point, because you don't see her say anything, you know, and then she calls him, "You fucking asshole." And apologize for my language, but I'm trying to quote to you exactly what was said on that day, on that phone call, which I urge you to listen to. But it's at the 2-minute and 40-second mark. Her voice, her inflection, everything changes, because at that moment, she has now seen Jermaine Bass, and she's seen him holding her boy. She says, "That man was playing with his freaking gun. I don't know what the fuck happened." Again, I don't know what the fuck happened. She doesn't know. All she knows is that her husband, of all people, had a gun, and suddenly gunshots are going off, and he walks out with his son in his arms. And that's when there's a realization, because you'll hear that now suddenly she starts to give some more specific. "My babies, my kid been shot." She doesn't say my kids, she said my kid. Singular. At this point in time, she probably doesn't even know Jayla's shot up there. But now she's seen JJ. "Bring the ambulance. My son is bleeding." My son. Again, she doesn't say Jayla. Why? Because at this point in time, she was outside and she sees her husband come out and he's got the boy. She doesn't even know what's going on with the girl. She doesn't realize that her daughter is dying upstairs. This is Shirley's testimony, ladies and gentlemen. Unfiltered, raw, emotional, at the time, the most trustworthy statement you could possibly get from an individual when they're in the experience at the moment going through it. And what is she telling you, ladies and gentlemen? She doesn't know what's going on, but she knows something bad is happening in her house, which means she's not there, she has nothing to do with it, she's not involved with it. The phone disconnects. You hear it come back in. If you listen, you can tell there's an echo. She's inside that house at that point. She yells at him, "Leave him alone, don't touch him." She says, "I swear to God, if my son died," and you can hear all this on that phone call. And yes, she's very rude to the 911 operator, but remember, she's now realizing that her son is shot in the head. She doesn't know what's going on, she doesn't understand it, but she knows that that man right there, Jermaine Bass, has something to do with it. That man playing with his freaking gun. You know, Ms. Schlemmer wants to talk about how uncooperative Ms. Bass was. What did the detective tell you? On the day this happened, while her daughter is lying there dead, and her son is in a coma in the hospital, she spends an hour talking to him about this. Think about this, ladies and gentlemen. This woman, whole world has just exploded. Everything has exploded. The husband, the man she's in love with, is now being investigated or believed to have shot and killed her daughter, and her son, who could potentially die, is there in the hospital. Her mind is reeling. And Ms. Schlemmer wants to sit here and talk about her cooperation. She spent an hour. Corporal Gabo told you, she spent an hour talking to me. And he went back the next day and talked to her for even longer. And Ms. Schlemmer wants to call her uncooperative? You know what uncooperative is? Is lying to police. Who do we know did that? Mr. Bass. She wants to get up here and tell you, well, he was cooperative that whole time. No, he wasn't. How is lying to police cooperative? They based, you heard Corporal Gabble, we based our investigation on what he said happened. They weren't looking for a whodunit or who's the other person that might have done this. He told them I did it. But it was an accident. So that's how they're basing their investigation. So again, remember, we talked to you earlier, we don't have to prove motive, okay? And I think you all understood that, and we went through that in some great detail. But I told you, you're gonna get some evidence that something was not right, and I think you heard it. You heard it from China Gadsden, who got up here. But she told you that she was being aggressively tailgated as she left Ruth's Chris. And that's why we presented all that evidence to you, to show you and to corroborate what China said to you. Because we know that that man left those kids alone, got in his Nissan Titan truck. We see him pulling out from the residence. We see him driving down Fletcher towards the interstate. We have his phone records that show his phone going all the way down to West Shore, where he's there for a couple of hours. Not sure what he's doing there, but he's there, waiting, until Shirley leaves, at which point he aggressively tailgates her. China's, what is this guy doing? She doesn't know it's him. The only evidence of anyone being aggressive, acting abnormal that night, is that man seated right over there. Not Shirley. How was Shirley? Shirley was fine. She was just normal. She was happy. It was her sister's birthday. We were all out at dinner. The only person with any sort of aggression that night was that man seated right over there. And we proved to you, ladies and gentlemen, that. And we don't have to prove to you motive, but something was not right. He was clearly upset with Shirley for some reason. You don't follow your spouse to a dinner, wait outside, and then aggressively tailgate your spouse. Your spouse is leaving the dinner, and then get up in front and stop them from driving anywhere, and then we'll go up and accuse them of drinking. You don't do that unless there's something very, very wrong. But Jermaine Bass took that anger home and unleashed it on his children. Whether to punish Shirley Bass or for whatever reason, we don't know, but he took that anger out and he put it into his children. Again, zero physical evidence to suggest Shirley Bass had anything to do with this. In fact, everything seems to indicate the opposite. You see her behavior, you see her franticness after this happens. You hear that 911 call. And I'm telling you right now, listen to that 911 call. That is raw, that is pure, that is when a person is experiencing the moment. And you can tell she doesn't know what's going on. She is frantic and scared. But the few moments that she says anything that you can tell that she knows something happened, is she is accusing that man right there. What the fuck is wrong with you? You know, Shirley was the one trying to attempt to get help for her kids. We know Mr. Bass had his phone with him because he made a phone call. While Shirley's out there going, get that ambulance here, send an ambulance. Is Mr. Bass calling 911? And Ms. Schlemmer says, well, Shirley was doing that. How does he know what Shirley's doing? She was out there. She was outside. She was outside trying to find a man to help her. Someone who could give her a phone so she could call 911. Most likely because she was too terrified to go back in that house, not knowing what's in there. So she finds a man who's willing to, who helps her, gives her a phone and calls 911. And what is he doing with his phone? He's calling his mom. He's not calling for help for his children who've just been shot. Is that what a father does?
Objection, Your Honor, improper argument.
Sustained.
This was an accident. I think the first thing you want to do is call and get some help. Certainly not put your gun away neatly and close the drawer and call mom. There were 4 people in that household. Jayla's gone. Sadly. JJ, Shirley, and Jermaine are in there. And I've shown you, I believe, and proved to you that Shirley could not have done this. She is excluded from the DNA on that gun. She never touched that gun. At least not the grip or the trigger. Physical evidence does not connect Shirley in any way to this case. Her behavior afterwards is typical of a person who's just gone through a serious traumatic event. What's not typical was the behavior of the father, of Jermaine. So the only other question is, Jermaine or JJ? Well, remember, don't ever forget this, the father is the one who admitted he shot that guy. And that's why Ms. Reeder spent so much time with that crime scene investigator to talk about the angles and everything like that. To show you, ladies and gentlemen, that that shooting came from off the bed. And we know JJ was shot on the bed. And then also ask yourself this, 2 people, right? Those 2, JJ shot himself in the head? That doesn't make sense. But again, no evidence of close range firing. The angle from which those shooting shows that the shooting came from off the bed. This was not JJ. JJ had nothing to do with these shots. JJ was innocently laying there with his sister, and that man walked in and brutally shot them both. That's what happened. It's so simple. It's right there in front of you, ladies and gentlemen. And you can pick apart a medical examiner's report of up or down.
I'm gonna object, Your Honor, improper argument denigrating the defense.
Sustained.
We can look at little things like that, but what we knew, don't forget and don't miss the biggest stuff in this case. The strongest, most compelling, biggest piece of evidence. And that is the statements from Jermaine Bass on that night and the statements from Shirley Bass on that night. You watch, look at that physical evidence, and you will know that these shots came from off that bed. That excludes JJ. No DNA of Shirley, that excludes Shirley. That leaves that man right there, and guess what? That man admitted he did it. It's very simple. This is not a complex case. There is no doubt whatsoever that on that night, on August 29th, 2022, Jermaine Bass, who told you he did, told those deputies that he did, that Jermaine Bass shot and killed his own daughter, Jayla Bass, and tried to shoot and kill his son. That, ladies and gentlemen, is murder in the first degree, premeditated, because look at the placement of those shots. This reader showed you that. There is a picture of Jayla Bass, and you can see those 3 shots, well placed, all within a very close range. Does anyone think an 8-year-old boy could do that? Really? Sure, an 8-year-old boy can fire a gun, but with that kind of precision and accuracy? That takes someone who knows how to fire a gun. You know, we did introduce a lot of evidence of a lot of other bullets. That's to show that Mr. Bass knows guns. Yes, there's clips, holsters, there's all sorts of stuff. There's that one thing where it has all the bullets in it. We presented that evidence to you, ladies and gentlemen, and proved to you and show you this was not an accident. This man knows guns and knows how to fire guns. He knows how to aim that gun. And he put those 3 bullets into the head of his daughter. And he put that 1 bullet into his son, who still has to deal with that 1 bullet. That's first-degree murder. That's attempted first-degree murder. And that is aggravated child abuse. Both counts. It's not only premeditated murder, it's felony murder, because he is guilty of aggravated child abuse for what he did to those children, and that makes it felony murder. And I'm convinced, ladies and gentlemen, that when you go back there, use your common sense. Think about what is the evidence to best rely on. The state has no doubt that you will return a verdict for guilty as charged on all 4 counts. Thank you for your time.
Thank you. All right, so it is almost 6 o'clock. My intention, unless you would like to vote to overrule me, is to go ahead and release you for the night, to come back tomorrow and begin your deliberations fresh tomorrow. If you would like to overrule me, I see a bunch of you nodding already, and would like to start deliberations tonight, I will certainly stay here and allow you to do that. But I see by the number of you packing away your materials that no one wants that option. Is that correct?
Correct.
All right. So a couple of additional admonitions, other than the usual: no discussion about the case, no watching the news or local media or any reading anything related to the news. But most importantly is my admonition about not coming to any definite, fixed, or final opinions on what you've heard. So a natural reaction is, oh, I've heard everything. I've heard the evidence. I've heard the final arguments to the lawyers. I've heard most of the law. There's a little bit left to read. But the reality is you have not engaged in the most important part of your deliberation process, and that's discussing the evidence with everyone else. So sometimes when I discharge people at the end of the day, they go home and come to such a resolute idea about how they're going to vote that it makes it hard for them to interchange information with everyone the next day. So I'm going to ask you to please try to do everything but that. Come to some final fixed opinions on what you've heard, that you're not able to intelligently discuss it with everyone tomorrow. Does everyone understand where I'm coming from? So just, keep your final thoughts to yourself. Allow for a thorough and usual debate on the evidence and deliberation tomorrow. So don't come to any such fixed opinions that you prevent yourself from doing that tomorrow, in other words. Any logistical questions before I let you go about any of those admonitions? All right. So same time, meet the bailiffs, 8:45, so I'll get you back.